Greetings, 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 greetings. It is I, King Clifford Jefferson, a Senator Godfrey the Fifth kind of band Jew, son of folk, ruler of Jerusalem. I am the reincarnation of King Edward the Peaceful, which we hear at the Third Temple English Church of England, called the Vicar of Christ, or Malachi Zodok, which means the King of Righteousness. It is November 7th, 2024, which is equivalent to the Berber year 2974. I greet you in the name of my Queen, Sister Galveston from the House of Galveston. I greet you in the name of our heirs and our successors, our predecessors, our martyrs, our saints, our children, our mothers, our fathers, our elders, all those who are or need to be getting an understanding of what it is that we are here and called to do. This lecture here today is called The 13th and the 14th Amendment. Was our choice to be free or slaves? The 13th and 14th Amendment was our choice to be either free people or slaves. All right. This is going to be a beautiful lesson for all my brothers and sisters, including the Moors and anybody else that's out there paying attention. I always like to use a precursor to discuss the topic today in regards to citizenship, as well as due process of law, as well as affirmative defense whenever your due process rights are violated as a citizen. But we must determine the status of citizenship here in regards to the due process that one receives here under the status of what we call citizen, because citizenship determines your status. All right. Of course, there's out there a lot of people who claim to be representing the people, i.e., the nation, i.e., their nation, according to their law. Okay, which is has been attested loosely as a result of the competency of the people which are in question in regards to that which needs representation. Okay, so when I speak on behalf of the Third Temple English Church of England, known as the Anglo-Saxon Burghers. All right, and we are represented by the supreme law of the land, which is called the Common Law of England. All right, so without further ado, let's get started with this marvelous lecture. I hope I get some visitors today to ask some intelligent questions. If not, stay mute and observe and digest what it is that has been divinely prepared for you in this day and time. So with that, let's get started. The uh, the what I'm going to use to tell this lesson is from the website called the House of Awakening Minds in regards to the Morris Consulars, Maurice L. And just some of the things that he say in regards to his position that he holds needs to be examined a little bit more in regards to that obligation that you have in the right that you have to represent your people whose rights have been infringed upon. How did you get that authority? Okay, we must understand that. So with that, we're going to use that as a template and as a guide to a better understanding. Okay, so let's get started. Testing, testing, testing. First, before we get started with the video, let's just get a couple of ideas on slavery. All right, slavery, very important. Before we even get started, the end of slavery. All of us can relate to this topic concerning the end of slavery. End of slavery in the United States. Okay, we know that slavery started from the what you call the sub-Saharan slave trade, and then from then you have what they call the Atlantic slave trade. I did a lecture on that previously, so if you haven't watched that lecture, please go back and uh, 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 please go back and watch it so that you can get a better understanding of where I'm trying to go with this lecture here in this present day. Okay, so a really reiteration on the end of slavery here in the United States, hanging on the hems of how slavery actually came about here in the United States. Okay, which we know is through the Atlantic slave trade. All right, I said from the 18th and the mid 19th century, various states of the United States allowed the enslavement of human beings, most of whom have been transported from Africa during the Atlantic slave trade or were their descendants. Once again, from the 18th and mid 19th century, various states of the United States allowed enslavement of human beings, most of whom have been transported from Africa during the Atlantic slave trade or were their descendants. The institution of child slavery was established in North America in the 16th century under the Spanish colonization, British colonization, French colonization, and Dutch colonization. Okay? After the United States was founded in 1776, the country split into slave states. States permitting slavery and free states prohibiting slavery. Slavery became concentrated in the southern United States. The act of prohibiting importation of slaves in 1807 banned the Atlantic slave trade, but not the domestic slave trade or slavery itself. This is reiterated in the Dred Scott case, which we'll talk about in a second. Slavery was finally ended throughout the entire country after the American Civil War in 1861 and 1865, in which the United States government defeated the Confederation of rebelling slave states that attempted to secede from the United States in order to preserve the institution of slavery. During the war, United States President Abraham Lincoln issued the Emancipation Proclamation for order the liberation of all slaves in rebelling states. In December 1865, the 13th Amendment of the United States Constitution was ratified, abolishing chattel slavery nationwide. Native American slave owners also persisted until 1866, when the federal government negotiated new treaties with the 5 civilized tribes, and which they agreed to end slavery. In June 2021, Juneteenth, a date that commemorates the end of slavery in the United States, became a federal holiday. So that's the basics of slavery that everyone should be able to comprehend or understand. But today we're going to go a little deeper based upon the origin where slavery come from and the end of slavery and the result and the choice that we have to make in regards to whether we will continue to be free people or slaves. Okay? And that came through the 13th and the 14th Amendment. All right. The 13th Amendment. The 13th Amendment to the United States Constitution abolished slavery and involuntary servitude, except as punishment for a crime. The amendment was passed by the Senate on April 8, 1864, by the House of Representatives on January 31, 1865. It ratified by the required 27 of the then 36 states on December 6, 1865, and proclaimed on December 18th, and it was the first of the three Reconstruction Amendments adopted following the American Civil War. That is the basic understanding on the application of the Emancipation Proclamation. Okay? President Abraham Lincoln Emancipation Proclamation, effective on January 1st in 1863, declared that the enslaved and Confederate controlled areas, and thus almost all slaves, were free. Okay? Were free. When they escaped the Union lines on federal forces, including now former slaves, advanced south, emancipation occurred without any compensation to the former owners. Okay? That's very important to understand the purpose of the Emancipation Proclamation and the institution of the 13th Amendment for those who were considered property, i.e., the Negro, blacks, coloreds, and whatever you choose to identify yourself with in this present day, including the word or the term Moorish American. Okay? Very important that you pay attention to where I'm going with this. Then you have the 14th Amendment. The 14th Amendment of the United States Constitution was adopted on July 9, 1868, as one of the Reconstruction Amendments. Usually considered one of the most consequential amendments, it addressed citizenship rights and equal protection under the law and was proposed in response to the issue related to formerly enslaved Americans following the American Civil War. Okay, look at the parties that are involved. The amendment was bitterly contested, particularly by the states of the defeated Confederacy, which were forced to ratify it in order to regain representation in Congress. The amendment, particularly its first section, is one of the most litigant parts of the Constitution, forming the basis for the landmark Supreme Court case decision of Brown versus Board of Education, regarding racial segregation, Levin versus Virginia regarding interracial marriages, Roe versus Wade regarding abortion, all the other case law, including Dred Scott versus Sanford, that we will address in a second. Okay? Very, very, very important. All right? So before we even get into understanding this lecture, the 13th and 14th Amendment was our choice to be free or slaves is based upon your understanding of the slave laws, the understanding of the emancipation, and the understanding what was there after your emancipation that you were there to pick up to be able to now preserve that was there prior to your slavery. Okay? There on that land. Okay? To claim you got rights or due process of law under any constitution or any treaty based upon individuals, it must be based upon something pertaining to your right to exist on the land. Not on the water, not in the air, not underground, but on the land. Okay? So you better be careful about what we say in regards to the freedom, the aspects concerning freedom and liberty of a nation of people here in what they now deem North America. All right? Especially when it involves titles and abilities, all right, equal rights, equal protection at laws, as well as the right to participate in regards to the uplifting of the political government based upon the what they call the participation. Okay, you must participate in your government affairs. All right. So with that, let's go to this video. I'm going to play the video and I'm going to let it play and we're going to stop it and just go through or review some of the things that are being said in regards to citizenship. Okay. And that has nothing to do with nationality. Citizenship just denotes to status, whether you have a nationality, whether of that country or a nationality of a foreign state. Okay? We must understand. So with that, let's bring forth the video.
Welcome to Office Hours with Dr. G. I'm your host, Dr. G. I'm so glad that you could keep our appointment. Now, tonight's guest is no stranger to Office Hours with Dr. G. You've heard him before, at least two, maybe three other occasions. But tonight, he's being joined by the group that he's working with, the Consular group in the Maryland Republic. I am talking about Reverend Lamont Maurice L., who will present This Is How You Do It, which would be a review of what occurred during a consular jurisdiction and treaty enforcement effort that they recently were involved in at the Maryland State Republic. Now, if you don't have pen and paper, I urge you to get something to write with or record what you're going to hear, because the information that they are going to share tonight is going to be very, very vital for many of you Moors who are looking for remedy for the situation that they're going to describe. Without further ado, I want to welcome back to Office Hours with Dr. G, Brother Lamont Maurice L., and Brother Adair. Thank you so much for being here. Welcome to the show. Yeah, that's me. How are you?
We are great.
Well, I didn't cover you up, with the little banner. I just realized as I was talking that you were there. We were there all the time. They can see us, but hey, those are the things that happen sometimes. But thank you so much for coming back on the show tonight. I'm excited. There's not a lot of talking. I'm gonna do most of my talking right here, right now, in this intro, as we're waiting for my theme music to play out. And I'm pretty much gonna let you all in your group, I know you're waiting for some others to arrive, but I know the two of you can get us started with what is, what has happened, and the stare decisis case that you have. It's always wonderful when we have precedent that we can say, I don't know, I don't think it works, I know it works. So welcome to Office Hours with Dr. G, and you're, like I said, no stranger. I think this is your third time as worth it before. I'm not sure.
This is one of the senior now.
You're graduating.
He's working on his undergrads.
Yeah,
Well,
this is the fourth.
Okay, fourth time. Wasn't sure. Well, it is my really, I'm happy to have you here. I'm happy that this platform is available, because when things like what you're going to share with the audience occur, it is good to be timely. I mean, we couldn't do it on the day of, but we're within a week of this, and so this is hot off the press. As far as I know, and it hasn't been widely advertised anywhere else. I thank you for the exclusive.
Thank you for the opportunity. Thanks for the opportunity. Thank you for your platform again, respectfully to acknowledge. I know that there's a lot of work and investment in time and energy and strength and all of that you put into giving us an opportunity to present some truths that may sometimes be kept under a rock or hid under a basket if you don't really push for the recognition of it. So you being a mother to us all, thank you for creating a platform in which we all can be able to come in respectfully to the purpose of why you even created it. And hopefully we can be able to get some remedy done for the rest of our people. Thank you again.
Islam, and yes, you do have the exclusive hot off the press.
Thank you so much. Thanks for that.
This will be considered like the press release, before the press conference.
Absolutely. Appreciate that. Okay. So listen, like I said, because I want to hear all I've heard, but I want to hear it in greater detail, just like, the audience would like to know what happened and how does it apply to them, and what they're trying to do. So, take it away. I may put you up on a solo, just so everyone, especially when everybody gets there, and make sure everybody sees you. I'll pop in and out. I'm not gonna leave. I mean, I'm here, but I don't have to be, right on the screen. So let me see what what happens when I bring you up like this. Okay, there you are.
Oh, we good. Okay.
There you go. There you go.
All right. So, you want to know what happened?
Absolutely.
All right.
Look, inquiring minds want to know. Wait a minute. Before there looks like about 100, a little over 100 people on the live. So what I need them to do is to give us a thumbs up, like, and share. We need to have 1,000 on this. This is something that needs to go far and wide. So while you're, getting your pieces, your paper and your pen so that you can take notes or whatever you're gonna take notes with, also like and share. I know you're probably already a subscriber, not subscribed, but like and share. Do like and share. Let somebody know that this information is hot off the press. There's a lot of Moors who are affected by what they're going to share. And once there's, a precedent has been set, stare decisis, what it's called, then this is something that all of those of us going forward will be able to use, to validate, if I'm using the right word, our cases if they come up like that. So while you're liking and sharing, Brother Lamont, Brother Derek, you have the floor.
Islam.
Islam.
Peace, everyone. So back in February, right now I'm looking at the certified copy of the two writs that was issued from our Morocco Consular Court at the Maryland State Republic jurisdiction. So one being a order of default, and two being a writ of quo warranto, certified by District Court of Maryland for Charles County. Of course, that's not a court. That is a private foreign de facto corporation. Nevertheless, they certified. I don't know if you all can see it. They certified the two documents, and our venue, of course, certified the two writs that we issued here. And for everyone, it is available for public display as well as public scrutiny on enforcetheconstitution.org. When you go there, you'll click on consular court cases. And when you click on consular court cases, you'll scroll down to where you see habeas corpus cases. You click on that web page and you will see, well, matter of fact, can we do screen share? Click this right here.
Before we let him continue, he mentioned two things in which the instrument that he was speaking about was presented on behalf of the consular Moroccan representatives. Okay, he said a writ and a quo warranto. A writ is pretty much one of the aspects that originated from the Crown of England, which quo warranto was one, as well as the habeas corpus. These are all writs that originated from the Crown of England. Okay, let's just revisit that before we go on. Quo warranto. In English American common law, quo warranto, medieval Latin for by what warrant, is a prerogative writ issued by a court which orders someone to show by what authority they have for exercising some right, power, or franchise they claim to hold. The writ of warranto still exists in the United States, although it is uncommon, but it has been abolished in England and Wales. Quo warranto also used with slightly different effect in the Philippines. When we say England and Wales, we're talking about the territory where we now identify as Great United Kingdom. Okay, the internal government in which the government of England was ran by was a moving government. It was called the Internal Court, which now resides here in what we call North America. All right, we must comprehend that. So the origin of the quo warranto originated in English common law before it became a part of Americans' law. Because American law is not the common law. The only common law of America is English. Okay? We must comprehend that. All right? And the origin of the quo warranto was the twin of Queen Imperatrix, passed by the Plantagenet kings, Edward I. Okay? Let me just show you that before we go on. And they don't represent representatives of the Plantagenet crown, in which the prerogative writ called the quo warranto, or any writ for that matter, originated from. Okay? Queen Imperatrix is a statute passed by the Parliament of England, not Morocco, all right? Not the More America, not the consuls. The Queen Imperatrix was a statute passed by the Parliament of England in 1290 during the reign of the Plantagenet King Edward I, son of Henry III, son of John, the son of Henry II, part so. Henry III, son of John, son of Henry II, the son of Godfrey the 5th Count of Anjou, son of Folk, the ruler of Jerusalem, and that prevented tenants from alienating their lands to others by subjugation, instead required all tenants who wish to alienate their land to do so by substitution. The statute, along with its companion statute quo warranto, was also passed in 1290, was intended to remedy land ownership disputes and consequent financial difficulties that have resulted from the decline of traditional feudal system in England during the High Middle Ages. So those terms, that term writ or quo warranto, originated from the Kingdom of England under the common law of England. Okay, we must understand that, and that is the property rights of the English people. No other person has the right to use the writs such as the quo warranto. If you're using it, you're unlawfully using it by an unlawful warrant. Okay, because it's called a quo warranto, or order to show just cause, how you're acting as a representative who created the quo warranto, because you didn't. All right, let's go back to the class.
Share screen. Entire screen window. Is my screen sharing? Hold on. Dr. G, is my screen sharing?
Not yet.
Not yet.
You have to click screen share.
Yeah, I did. Now it says choose what to share. Entire screen. Yeah, but it's not giving me the option.
I don't see your
Hold on. Okay. Share. It says share screen.
I'll just kick out of. Okay, try it again.
Yeah, it's not giving me the option to click on share.
Let me see. Is that your screen right there? That's up. Or that must be yours. Pick what you want.
Oh, I gotta click it. My apologies.
All right, now.
All right. So now, what you see on the screen is the website enforcetheconstitution.org.
I'm trying to bring you out, but let me fix it. I see it, but it's not letting me. I just can't. But here we go. Add to stream. And there it is.
There we go. Thank you, Dr. G.
Habeas corpus is also another form of writ. That's a prerogative writ of the crown, which means bring forth the body. Okay? We must understand that as well.
So you'll click on Enforce the Constitution. You'll go to enforcetheconstitution.org. Consular court cases here. And when you click on consular court cases, this is what will pop up. And you can choose the habeas corpus cases link. This will pop up. You can also reach this link when you click on the Dropbox More and scroll down to where you see habeas corpus cases. When you scroll down on this webpage, you'll see Morocco Consular Court at Maryland. Then you'll see pictures from June 17th. And what you're looking for ultimately is the PDFs. The first PDF that you will see is titled Certified Writ of Warranto. And it's here. And it's free, of course, you can download it. It's a PDF. Also, the certified order of default. And like I said, it was certified by Morocco Consular Court, our court, as well as their foreign corporate venue. Now, what the cause was for the issuance of these two writs was, you scroll down below that, you'll see the Sharice return, and you will see the writ of habeas corpus that was certified by Morocco Consular Court and issued by Morocco Consular Court and recorded in the records of the District Court for Charles County. So that's a PDF too. And then you scroll lower, then you'll see Circuit Court from Montgomery County. That's the case dealing with another issue. So it started with, let's see, this writ of habeas corpus. And
Can I interject? For the benefit of those who may not know what habeas corpus means, could you start by explaining that?
Yes. So the brother Dill, he's going to get the habeas corpus definition so that I can read it in the Black's Law 4th edition. But habeas corpus means that you have the body. Writ of habeas corpus means an order that you have the body, and then ad subjudienda means to be produced from subjugation. So writ of habeas corpus ad subjudienda simply means an order to produce the body from subjugation. So in the Black's Law Dictionary, 4th edition on.
Before we let him read the Black Law Dictionary, let's just get a good definition of what a prerogative writ is. All right? Very important. Okay, prerogative writ. Just look it up. Not use these words loosely. Okay, not use these words loosely because people are. All right. Prerogative writ is a historic term for a writ official order that directs the behavior of another arm of government, such as the agency, official, or other court. It was originally available only to the crown under English law and reflected the discretionary prerogative, extraordinary power of the monarch. Did you hear that? Did you hear that? Okay. Writ circulator, habeas corpus, mandamus, prohibition, quo warranto, as well as rulemaking on ultra vires cases. Okay, all this originated under English common law. Okay, the sixth writ, as I just said, is a writ circulator to certify habeas corpus, circulator, and ordered by a higher court, directing a lower court to send the records in the given case for review. Habeas corpus demands that a prisoner be taken before the court to determine whether they have lawful authority to detain detain the person. Mandamus is an order issued by a higher court to compel or direct lower courts or government officers to perform mandatory duties correctly. Prohibition, directing a subordinate to stop doing something that the law prohibits. Procedental, to send a case from the appellate court to the lower court with an order to proceed to judgment, and as well as quo warranto, requiring a person to show by what authority they exercise a power. All this is a part of the jury gallery of the crown, who is represented by the king as the corporation soul. All right, they do not represent a corporation soul. They represent a consular representative or a consular officer based upon some international foreign authority here on this land. That has nothing to do with their representation, has nothing to do with their rights here on the land. It has to deal with their representation based upon the contractual parties, based upon the contractual agreement that's within question. Okay, we must comprehend that. All right, let's go back to the video. See if you know where the prerogative writs originated from.
This stuff right here fixed my back pain. Now check this out. I had cancer when I was younger, and I had to have. So you've expanded and changed the Republican Party.
What happened to the video? Bear with me, y'all.
By it.
Okay.
That is the Constitution. To the
Sorry about that, y'all. Here we go.
Properly plan and not have a poor performance. And on date was this? Give me 1 second. On June, Writ and
Just drawing back some more.
the habeas corpus case is linked. This will pop up. You can also reach this link when you click on the Dropbox More and scroll down to where you see habeas corpus cases. When you scroll down on this webpage, you'll see Morocco Consular Court at Maryland. Then you'll see pictures from June 17th. And what you're looking for ultimately is the PDFs. The first PDF that you will see is titled Certified Writ of Quo Warranto, and it's here, and it's free. Of course, you can download it. It's a PDF. Also, the Certified Order of Default, and like I said, it was certified by Morocco Consular Court, our court, as well as their foreign corporate venue. Now, what the cause was for the issuance of these two writs was, you scroll down below that, you'll see the Sharice return, and you will see the writ of habeas corpus that was certified by Morocco Consular Court and issued by Morocco Consular Court, and recorded in the records of the District Court for Charles County. So that's a PDF too. And then if you scroll lower, then you'll see Circuit Court from Montgomery County. That's the case dealing with another issue. So it started with, let's see, this writ of habeas corpus. And
Can I interject? For the benefit of those who may not know what habeas corpus means, could you start by explaining that?
Yes. So the brother Deal, he's going to get the habeas corpus definition so that I can read it in the Black's Law 4th edition. But habeas corpus means that you have the body. Writ of habeas corpus means an order that you have the body, and then ad subjudienda means to be produced from subjugation. So writ of habeas corpus ad subjudienda simply means an order to produce the body from subjugation. So in the Black's Law Dictionary, 4th edition, on page 837, habeas corpus, Latin, you have the body. The name given to a variety of writs, of which these were anciently the emphatic words, having for their object to bring a party before a court or judge. In common usage, and whenever these words are used alone, they are understood to mean the habeas corpus ad subjudienda. The sole function of the writ is to release from unlawful imprisonment. So on that same page, you go to the term habeas corpus ad subjudienda. It reads, a writ directed to the person detaining another and commanding him to produce the body of the prisoner or person detained with the day and cause of his capture and detention. Then it says ad faciendum subjudiendum et recipiendum. That means to do, submit to, and receive whatsoever the judge or court awarding the writ shall consider in that behalf. So, and also let me finish the definition. This is the well-known remedy for the deliverance from illegal confinement, called by Sir Williams Blackstone the most celebrated writ in the English law.
Did you hear that? The most celebrated writ in English law. But you're not English. That writ don't apply to you. No, you have the authority to use that writ because you're not English. That's why it don't work.
And the great and officious, whoa, wait a minute. Hold up. It's the efficacious writ in all manner of illegal confinement. The great writ of liberty issuing at common law out of courts of chancery, king's bench, common pleas, and executure.
Did you hear that? Did you hear that? That's why chapter 29 of the Holy Quran, Circle 7, is so important. Okay? That's why it's there. They're telling you that the only remedy you got is to petition the king under the 5 writs that was mentioned. Okay? But you have no king. So if you petition under the writ to those who don't have the authority because they're not the king, then damn it, they're going to deny the writ because it's discretionary now. It's not a right. Okay? It's not a right. I don't see no comments. Nothing in the comments. Well, I don't see nothing in the comments. Oh, that's a bunch of crap. Oh, you talking trash. What's going on? Okay, but yet they have thousands of followers being led astray by not applying the law. When you don't apply the law, you waste the law. Okay, and we talk about waste. All right, let's look where their authority comes from based upon Article 3. All right, Article 3 deals with conflicts or matters concerning citizenship on the diversity issue, but their issue in regards to diversity issue as citizens or national of Morocco has nothing to do with matter concerning citizens from different domiciles concerning the land that you're on. All right, this is what you're overlooking. I'm not just saying that, just look at the statute before we go back to the video. Suits affect ambassadors, other public ministers, or consuls. Section 2, Clause 1. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which should be made under their authority. Semicolon. To all cases affecting ambassadors, comma, other public ministers and consuls, semicolon. To all cases of admiralty and maritime jurisdiction, okay? Admiralty and maritime jurisdiction, that's matters concerning obligations on water. So that can either be riparian rights or littoral rights, okay? Riparian rights or littoral rights, okay? You must understand that. So to all cases of admiralty and maritime jurisdiction, to controversies to which the United States should be a party, to controversy between two or more states, between a state and a citizen of another state, between citizens of different states, and between citizens of the same state claiming land under grants of different states, and between states or the citizens thereof and foreign states and citizens or subjects. The main key is states or citizens or a citizen against a state in regards to matters of land grants. Okay? Land grants. Land grants are governed by the supreme law of the land, not by a treaty that took place either on land or on water, all right, that has to do with individuals who made them, not the state itself, because the state is still under a obligation prior to that creation of that treaty. Okay? Very important that you all comprehend that. Because most Americans or consulars are not citizens based upon for the sake of an argument concerning status here in North America, because that's based upon your corporate domicile. Your corporate domicile determines your legal status as incorporated in the state by what? Your primary the primary aspects of what your organization or corporation or society, civic organization does. All right, that determines your status. Okay, but as a national dealing with citizenship based upon you being a citizen, whether foreigner by what we call permanent resident or a national by being blood and born on the soil, all right, that determines a different status in regards to citizenship, meaning status, because status and citizenship is synonymous. Okay, it all denotes the status. All right, you can have a status as a national, you can have a status as a foreigner, and you can have a status as a resident simply by residing somewhere as a result of you living there because you're employed there. And yes, citizens are employees of the state in which they reside based upon their residency. Why? Because you have nothing to prove that you are in fact a national of that country. Okay? If we're now dealing with citizenship and claims governing land grants, okay? If you're just dealing with treaties governing controversies in regards to parties, then that's a different scope of argument, okay? We must understand. Thank you, Countess Middleton. Oh, I'm gonna validate this, all right? Let's go back to the video. They're gonna tell you on themselves. November is the month of revealing. So anything that they present in regard to some affirmative defense based upon any party represent is not going to work. Why? Because they are not citizens under the common law of the land, whether what land they are in any state within the United States, because they're all governed under the common law of England. Okay? United States versus Juan Kim of Arc is going to show you that the only status here in North America is English nationals. All right? Let's get there.
So, habeas corpus is used, the office of habeas corpus is used for the sole purpose, as said in the definition, to release from unlawful imprisonment. So,
freedom.
Habeas corpus was issued for our brother, Moorish American national Jabbar Abdul Adel, who was being detained at the prison of war camp known as Charles County Detention Center. That detainment has been since, and I'm going to the records, give me 1 second, since February 14, 2021. Now, when we issued the writ of habeas corpus, of course, it was recorded in the records of Charles County District Court. We got a copy, a true test copy of it, which you all will see here on the website. And the true test copy, of course, you know, when they true test something or when they certify something, that means they've given it full faith and credit because they made it a part of their records, even though they're not a court. So it can be enforced at their jurisdiction. So Brother Adele, who's our vice consul, and I, who I'm the consul general, not of Maryland, the consul general of Morocco, by vote, served the writ of habeas corpus as suggested upon an agent for Sheriff Troy D. Berry, who's acting as the sheriff for, not Montgomery County, sheriff for Charles County, Maryland. And also the foreign hybrid European colonist male, Brandon Foster, who's acting as the director for Charles County Detention Center. As you can see, according to this Sharif's return, it was returned by our acting Sharif, Adil Zakat Saeed Bey, who's sitting on my right. And it's shown that it was served 4:36 p.m. on March 10th, 2021. And it was
all right, so they're talking about process of service served by sheriff. The origin of the word or the term sheriff is reeve. That's a term originated from common law. Okay? Common law term for the English representative. Okay, let's just pull it up in case those who don't know. When you raise these arguments, the courts look at you like you crazy. Sheriff is a government official with varying duties existing in some countries with historical ties to England where the office originated. Did you hear that? Did you hear that? They're not English people. So how are you sending out sheriff to due process of service on behalf of the court? You must be an officer of the court, and if that's the case, it must be that what we call the King's Bench. Okay? We must comprehend what's going on. All right, let's go back to the video. It's not to pick on these brothers and sisters, but just to properly informed them that ignorance of the law is no excuse.
Accepted by someone calling or going by Master Sergeant Bernier. Now, at that point, they had 72 hours to either release our national or to respond and answer the writ of habeas corpus ad suggestionem. They did not do that. They did neither one. As a matter of fact, I personally called the detention center and I spoke with an acting lieutenant, and he said that they're not releasing him because he's being held under the order of who they call Judge Hennessy. And of course, you know, they're not our judges. They're not judges at all, unless we call them that. So when I was given that information, I knew that, you know, it's time to turn up pretty much.
I know, that's how it shows up.
That we had to do.
I'm not concerned about what it said.
To peaceably resolve this issue.
And that's on their end.
At the same time, enforce the treaty obligations that they all have. So we began to train and we began to study so that we can show ourselves approved, so that we can properly plan and not have a poor performance. And give me 1 second. On June 14th, 2021, so what is that? For March, April, that's 1 month, June. 3 months. Took us 3 months and maybe some days to train and study so that we could positively and effectively enforce the writ of habeas corpus as suggestionem was released. So what our Morocco Consular Court at the Maryland State Republic did was we issued an order of default due to Sheriff Troy D. Berry and just the other one's name, Director Brandon Foster, failing to execute their duty. So what I'm going to do is I'm going to read the order of default. And that can be found, like I said, right here on the website, Certified Order of Default. I'm going to read the memorandum. On February 14th, 2021, near corporate La Plata, Maryland Republic, our Moorish American national, Jabbar Abdul Adel El, was exercising his right to travel and was kidnapped, held hostage for profit, and denationalized under color of law.
Stop. So it say he was arrested as a result of traveling. When he was traveling on the land, the only instrument that they used to identify him was the instrument that they used to giving citizens, but not because they are national of the country, but because they reside at some type of residency within the state where it was corporately domiciled based upon its primary business, which is to keep you enslaved by being employees of that state. So when he claimed to be a national or a citizen of that state, it should have been based upon some incorporation instrument that validate that he was in fact and indeed a citizen on a national or foreign level. Okay? If you are a citizen on a national or foreign level, that means that something must reflect that and something must protect that in the municipal law, which is the law of the land. Yeah, you arguing citizenship, but not citizenship of the land, because citizenship determines one's status. Citizenship and national are not the same, which he's going to say. Let's see.
That is to say, traffic law on the information of the fictitious corporate name nom de guerre inscribed in all caps. That is to say, Jabbar Abdul Adel El. Yes, they took his pre-national name and put it in all caps.
Stop. We see that the driving license or the standard ID form governed under the Real ID Act has not or is not proof as one's nationality and citizenship. No state can give you proof of one's nationality or citizenship or one's foreign status, which is the citizenship. The public record must do that because the public record is there to protect the citizenship based upon the entrustment that the citizens placed upon those who are sitting in those official capacities. And they are obligated to protect the expectancy of the citizens' rights that's put on the public record. The the court record, nor the court record of the district court, state court, municipal court is not a court of public record. No, any record that you go down and file is a court of public record if it has nothing to do with a citizen. Okay? Because now, in order to go any government building based upon the Real ID Act, you must have that corporate ID for motor vehicles in your pocket. So if that determines your citizenship, i.e., status as a resident, going to any government building within that state based upon that residency, you are in fact and indeed an employee. Okay? We must comprehend.
Still does not make that you, right? Still a non de jure. Race, black, via the black code, as a stateless person within purview of the plausible 14th Amendment, under the custody of W. Lewis Hennessy, a foreign hybrid European colonist male. Patrick H. Lovelace, a foreign hybrid European colonist male. Troy D. Berry, a 14th Amendment U.S. corporate stateless person male. Brandon Foster, a foreign hybrid European colonist male. And Anthony B. Covington, a 14th Amendment U.S. corporate stateless person male. Hereinafter defendants, absent of a lawful Fourth Amendment arrest warrant and without due process of law.
Stop. All his remedy comes based upon he claiming that the parties who bring in the charge are 14th Amendment citizens. Okay? He claimed they are 14th Amendment citizens that violated his right as a citizen. Okay? Which he claimed to not be a 14th Amendment citizen. All right? He said he had some prior right under some law that was supremacy on that land. And it's not Moorish law, right? Because the law in which he's invoking based upon his due process rights originate from English law, but he's not an English national. He's a Moorish national calling upon the prerogative power of a core warranto. All right? We must comprehend that these brothers and sisters are just a little bit confused. Okay? We must understand that. And he's talking about the 14th Amendment. This lecture is called the 13th or 14th Amendment. Was your choice to choose freedom or slavery? Apparently they chose slavery based upon their comprehension of the 14th Amendment when they or their ancestors were emancipated based upon the 13th Amendment. But they didn't read the disclaimer clause. All right? There is a disclaimer clause in the 14th Amendment based upon the status of citizenship here in North America, which is different from foreigners, contrast to those who are nationals. Okay? We must comprehend that. All that's going to be brought out today. Okay? So any of you Moorish Americans or members from the Moorish Council want to sit down and intelligently talk this out like representatives of a nation, then we are open to it here at the Third Temple English Church of England, because we are in fact and indeed a nation. All right? Let's continue.
The incident was witnessed by Brenda Leonard Rufus L., the mother of Jabbar Bill Addo L. She was on the scene and I was on the phone at that time, February 14, 2021. Then we mentioned Kent versus Dulles. We also mentioned the case law McNally versus United States, quoting United States versus Holster. You can read those on the document on the website. For the sake of time, I'm not going to read those case laws. On March 5th, 2021, the Bis Morocco Consular Court issued a writ of habeas corpus as justicienda for the immediate release of Jabbar Bill Addo L. from the custody of the defendants based upon the facts shown in the Affidavit of Evidence and Information, Exhibit A, and Attachment Exhibit A1, presented to this consular court on March 5th, 2021 by our Sharif Eric Khalil Bey and witness Brenda Leonard Rufus L. The writ of habeas corpus was issued under consular jurisdiction upon the treaty rights of Jabbar Abdul Adel, which includes his treaty right to be immediately released from being made prize hostage by any of the citizens of America, and his treaty right to consular jurisdiction, which are guaranteed to be secured under Articles 6 and 20 of the Treaty of Peace and Friendship of 1836 between the United States of North America and the Moroccan Empire, and under Article 6, Clause 2 of the Constitution for the United States of North America, which we all know as the Supremacy Clause.
You are not an embassy. You're not an embassy. You don't have the authority to speak on behalf of foreign nationals. Okay? You don't. All right? Unless you are incorporated in the state to do so. All right? You must be incorporated in the state to do so, and that should be put on the court of record based upon it being protected on the public record. And the states are entrusted to protect that. But you didn't use anything on the public record to protect that, in which you use on the court of record based upon your due process rights, because everything you just quoted was based upon the prerogative power and the prerogative writ of an English monarch or an English king, which chapter 29 of the Holy Quran, Surah 7, calls for. Okay, it calls for that, but you have abandoned that obligation and the procedural guidelines for the protection of the citizens as well as yourself. Okay, let's continue.
And it says, see Colabrat versus Oregon. This is a very important case law for everyone to understand and to study, because it applies to all Moorish American nationals who are foreign to the United States jurisdiction, which is corporate and de facto and notwithstanding. So, for the purposes,
every state within the United States is corporate in nature. It's called a corporate domicile. Okay, it's called a corporate domicile. The corporate domicile is determined by its articles of incorporation, which pretty much set the tone for the status of the citizens, because yes, corporations are citizens. The type of corporation determines the status of the citizens, whether it's a living or a natural or an artificial person, i.e. a corporate fiction. Okay? But still, they are in fact citizens, governed under the laws where they are or where they reside. Okay? If there's no law to protect the citizen who are born there in blood, not based upon some type of joint resolution or some bill or some treaty, but based upon the supreme law of the land. Okay? The supreme law of the land. The supreme law of the land is not the Constitution. The supreme law is not the treaty. The supreme law of the land is based upon the customs of that land. All right? The customs of that land before it became written down. All right? And you just said English common law. Let's get there.
Consular notification requirements, as it is stated and asserted in the United States Department of State Consular Notification and Access Manual, 2018, 5th edition. Anyone who is not a U.S. citizen is a foreign national. And it also says there are rare situations in which a person is neither a foreign national or a U.S. citizen.
He said, if you are not a U.S. citizen, you are a foreign national, which means that you are a naturalized citizen here in North America. Because based upon the Naturalization Act of 1790, as stated in Wade versus Ahmad, which we'll review in a second, it says the idea of citizenship here in North America, based upon the founding fathers' idea, had nothing to do with genetics, ethnicity, etc. It was based upon the color of your skin. So therefore, those who have the darker complexion of skin cannot be a citizen based upon the Calvin's case dealing with foreign nationals. It goes back to the Elizabeth's Religious Settlement Act, or under the Naturalization Act of 1790, which deals with the founding fathers and those who were under the laws of the colonies, denoting to their type of citizenship was corporate in nature as well. Chinner versus Georgia qualifies that, as well as the 14th Amendment, which was the type of citizenship for those who are emancipated through the 13th Amendment as a result of the executive order passed by Abraham Lincoln. And that left the decision for you to choose what you wanted to be, a naturalized citizen or a national citizen or just an employee working for the state. Okay? You're going to see that with this lecture right here. All right, let's see. I'm sorry.
Sir, 4:36 p.m. on March 10th, 2021. It was accepted by someone going by Master Sergeant Bernier. Now, at that point, they had 72 hours to either release our national or to respond and answer the writ of habeas corpus ad suggestionem. They did not do that. They did neither one. As a matter of fact, I personally called the detention center and I spoke with an acting lieutenant, and he said that they're not releasing him because he's being held under the order of who they call Judge Hennessy. And of course, you know, they're not our judges. They're not judges at all, unless we call them that. So when I was given that information, I knew that, you know, it's time to turn up pretty much the activities that we had to do to in order to peaceably resolve this issue, but at the same time enforce the treaty obligations that they all had. So we began to train and we began to study so that we could show ourselves approved, so that we can properly plan and not have a poor performance. And on, give me 1 second. On June 14th, 2021, so what is that, March 8th, then you are considered by representatives and de facto officers access manual
from here,
2018 5th edition. Anyone who is not a U.S. citizen is a foreign national. And it also says there are rare situations in which a person is neither a foreign national or a U.S. citizen. That is to say, is stateless.
Stateless.
Consular notification requirements do not apply to stateless persons. That's what it says in their foreign policy manual for consular notification and access.
So either you're a national, foreign national, or a stateless person. Only three. Foreign national, a national, or a stateless person. Y'all better write that down.
Stateless persons include persons branded Negro, Black, Colored, Indian, Hispanic, Latino, etc. Right? African American. Right, yeah, African American as well. That's not.
Those are stateless people, y'all.
2 consonants. So those brand names that are in association with the Black Code are actually classifications. They're classifying people as undesirable, all right? Undesirable is a stateless person. A stateless person is a person without a nationality or a nation. Nationality and citizenship is synonymous.
You hear that?
Those words are synonymous.
He said nationality and citizenship are synonymous. That is not true. You just said a national, he was not a United States citizen, is considered a foreign national. A foreign national here in America has the status of a naturalized citizen and not a national because you left your national country where you come from. So unless this nation is governed by the nation's laws, then you are not a national here in North America because America is not governed by the nation's law governed under Morocco. Okay? You're not a national. You might be a foreign national, but because you own this land, you are subject to the laws of this land. All right? They're not going to just allow you, because if they allow you, then they got to allow every other foreigner the same right. Okay? That's what you call due process of law. So they are not nationals here in North America. They are foreign nationals because Morocco and North America is not the same based upon the body of politics. They might be same based upon geographical affiliation, at being that they were connected at one particular time, specifically New Jersey and Morocco. All right, but it has nothing to do with the political science that was created by the people. That you must understand. Okay, and let me just prove that right quick to show you that Morocco was in fact a part of New Jersey before Moroccans, Arabs, Moors, Berbers even came, or the term Berbers associated with some type of genealogy or ethnicity even came into the picture. All right? The term Morocco was connected back thousands of years ago, but they just chose the word Morocco when we know Morocco is associated with the Maghreb. And Maghreb was inhabited by Berbers before Arabs came here, which is the reason why you are called Moors today, because of the amalgamation between Arabs and Berbers. Okay, and we go to the what we call the sub-Saharan slave trade. It'll show you that Berbers were in fact enslaved by Arabs, which the Atlantic slave trade originated from that. Okay, we must comprehend. All right, let's look up Morocco real quick. Back in the Triassic period, all right, back in the Triassic period, almost all Earth's landmass was concentrated into a single supercontinent centered more or less on the equator called Pangaea. All the land. This took the form of a giant Pac-Man. Okay, that's where the game Pac-Man comes from. All right. The remainder was the world's ocean known as Panthalassa, all the sea. All the deep ocean sediments laid down during the Triassic have disappeared through subduction of oceanic plates. Thus, very little is known of the Triassic open ocean. The supercontinent Pangaea was rifting through the Triassic, especially late in that period, but had not yet separated. The first non-marine sediment in the rift that marks the initial breakup of Pangaea, which separated New Jersey from Morocco, are of late Triassic age, and the United States. These thick sediments comprise of what we call the Newark supergroup. Okay? So before you had the people of that territory, that this territory that you call Morocco was connected to New Jersey, which we reside in, and we are known as Anglo-Saxon Berbers because we know that the government of the Anglo-Saxon Berbers was that called written, and the laws were called the Magna Carta, the unwritten code, as well as the territory in which Morocco is composed of, which is composed of Berbers. Okay, these are indisputable facts. All right, had nothing to do with the Arabia Peninsula, had nothing to do with Mecca, etc. No disrespect to Mecca and Arabia. Okay, let's go back to the video.
Synonymous with each other. So you can take nationality out and put the word citizenship. Means the same thing.
Okay.
However, there's different levels.
He said you can take nationality out and put the word citizen in, but it means the same thing. But now he's about to correct himself because he realized he made a mistake. Okay? That's it.
Levels, or shall I say different classes of citizenship.
Let's
Just
move back.
because you call yourself and assert it in the United States.
Let's back up some.
Undesirable is a stateless person. A stateless person is a person without a nationality or a nation. Nationality and citizenship is synonymous. Those words are synonymous with each other. So you can take nationality out and put the word citizenship. Means the same thing. However, there's different levels, or shall I say different classes of citizenship. Just because you call yourself a citizen doesn't make you a citizen of either the United States or a citizen of America, or even a citizen of the Moroccan Empire, which would also be known as national of the land. You have to identify the pedigree because citizenship comes by way of jus sanguinis. So if your citizenship is Moorish American or Moorish American national, which is the same thing, then you are considered by representatives and de facto officers of the United States corporation platform jurisdiction. You're considered as a foreign national because foreign deals with jurisdiction. Foreign does not deal with land. Foreign does not deal with location. It deals with citizenship. It deals with jurisdiction. All right. So you are a foreign national in relation to the United States, right? So.
Okay, so you say you are a foreign national in relation to the United States. Okay? If you're a foreign national relative to the United States, that means that you have to prove that you are in fact have the right to be there in the territory which you reside. If you're not a citizen of the United States, okay? Because we know citizenship denotes to status, and you can be a national or a foreigner or just a stateless person. I didn't say that. The words came out of his mouth. So if he's a foreign national or not a stateless person, as they say, that means that the nation that he claims to be here in North America as a foreign national must be recognized based upon the common law of that land to be a foreign national. Because if you don't have a law to recognize you being a foreign national, then 9 times out of 10, the word national, as interpreted by the definition of the United States Code, Title 8, means your pledge of allegiance or your oath of allegiance. Y'all better listen to me. Y'all better listen to me and stop listening to these people who don't know what they're talking about. All right? Citizenship and national is not the same. Let's prove it. Hold that thought. Okay, sorry about that. All right, so if you're not a national, i.e., which is one of the stats of citizenship, and you're not a foreign national, which is another stat of citizenship, then the only stat you can be is that of a stateless person, which makes you a bastard. All right. The 14th Amendment is not unconstitutional, Mr. Philip Partham. It's not unconstitutional. That's what you've been taught to think, that is unconstitutional. It's unconstitutional for some, but it's not unconstitutional for the English people, okay? Because the 14th Amendment was the law that made you a citizen. What law is what needs to be questioned that made you a citizen, Mr. Philip Partham II, okay? Oh, you got the document. Well, we're gonna go through the document itself. Okay, so hold on a second. All right, hold on a second. Let me ask this: are you a Moorish American, Mr. Philip Partham II? You're from Georgia. Yeah, okay, that's what you have. I'm going to prove you wrong, so just give me a second, okay? Now, don't ask too many questions. Just slow down. And you're not a citizen or a national either. Okay, so one, you're not a citizen or a national. You can't be a citizen because the 14th Amendment is unconstitutional, and you said you got the document. Okay? All right. Well, let's work with that. All right. Okay, no questions. Let's see. Let's visit that. All right. Let's take a look at the 14th Amendment. All right. Let me just pause this right quick. Let's go look at the 14th Amendment. Because there's only three status here in North America. Either you're a naturalized citizen, which you claim to not be. All right, you're not a naturalized citizen. You're not a national, because you just said that you're a non-citizen national. You said, I'm a non-citizen national. Okay, I appreciate that. Thank you for coming to the class today. Let's just disqualify that thesis. All right. The 14th Amendment. So if you keep texting, I can't answer the question. And if you continue to do that, I'm just going to move forward and not answer your question. Okay. You made a valid point. That don't mean the point is true. Okay. You made a valid point, but that don't mean the point is valid based upon your observation. So just check me out. Just listen to me. The 14th Amendment to the United States Constitution was adopted under the Reconstruction Amendments for formerly enslaved Americans. So I can, one, assume that you are an enslaved American, and two, that you are in fact an African American, because those who were emancipated by the 13th Amendment were in fact African American, known as Negro, Black, Colored, Ethiopian. What they said in the video were stateless persons. They weren't foreign nationals, nor were they nationals. Hell, United States citizens under the 1790 Naturalization Act was not nationals. Okay? They were not national. All right? So the 14th Amendment make those who were property, i.e. Negro, Black, Colored, Ethiopian, stateless persons, now citizens. What type of citizens is yet to be determined, because it just means statuses. Citizenship means status. Okay? And there's only three types of status denoted to citizenship. Either a national of the country by blood, as well as being born there, or a naturalized citizen by way of permanent residency, as well as being born there pursuant to that permanent residency, or you just there by way of what we call conquest, discovery, or by way of being squatters. Okay? Oh, so you're a Yamasee Moor, so that's even better. All right? So I can put you in the group with everybody else. All right, now check this out. The 14th Amendment that made us citizens which you say is unconstitutional, is determined based upon your understanding of the 14th Amendment and based upon prejudice. Because you just said the Dungy case. All right, I haven't read that case, but I'm not going to be able to use that case because it's disqualified. All prejudice is not prejudice if it's not prejudice based upon the common law. All right, let's qualify this. Let's go to a common law prejudice to disqualify the Dungy case. United States versus. Before I go, let's go here. Enre Ahmad Hassan. Okay. Enre Ahmad Hassan. Write this down, Mr. Pathan. Write this down. The English know this case already. To summarize the approach which must be followed in deciding whether a particular person applying for citizenship is a white person within the meaning of the Naturalization Act of 1790 as interpreted by the Supreme Court, it is necessary to determine first the particular group or racial subdivisions to which the individual belongs. Its practical effect, proof of this fact is a matter of, you hear this, genealogy. Genealogy. An individual who presents an aberration from the color of skin of the group of which he is a member, such as a light-skinned Chinese or Japanese or a dark-skinned Anglo-Saxon, does not thereby acquire different status under the act from other members of his group. So you said that you are a part of Yamasee Moors, but Yamasee Moors has nothing to do with a nationality based upon the laws of that land, which determines if you're a national or foreigner or a stateless person. Because if you're a Yamasee Moor, then you pretty much are a stateless person. All right? Of course, when an individual applying for citizenship has the skin of a different color than is usual for the member of the group from which he claims to come, a strong burden of proof then rests upon him to show by the usual methods of proving genealogy that he is in fact of a member of that group. After the individual has been traced into that group, okay, after you've been traced into that group, the second question which the court or you must answer is whether the members of that group or society called the Yamasee Moors are part of the group as intended, as Congress intended in the 1790 Naturalization Act. All right? You must first determine that. And deciding the latter question based upon the Naturalization Act of 1790 and how the founding fathers determined citizenship, you, Brother Patton, are not a citizen, which is right. You are not a citizen. I totally agree with you. But you must have some type of citizenship. You said you are a Yamasee Moor. Okay? You said you are a Yamasee Moor. All right? Yamasee Moor is just a tribal group from somebody identifying with the term Moor. And Moor is not a nation. There's no nation called a Moorish nation based upon the geographical location, based upon your corporate domicile. Nowhere on the planet. Nowhere on the planet. All right? Let's go to another case. United States versus Singh Tucker Do, 1904 case. As you're constantly typing, you're not going to be able to see the prejudice that I'm giving to you. I'm talking about me. I'm an Anglo-Saxon Berber. And I just showed you one case based upon that I am not only a citizen based upon the 14th Amendment, but I'm a citizen based upon having a nationality because I can trace mine going back to a genealogy. All right? Genetics, ethnicity. You have yet to do that with the status of a Yamasee Moor. Okay? We have United States versus Singh Tucker Do, 1904 case. It's prejudice. Okay? But it is said that the applicants do not prove before the immigration officer that they were citizens, that some simply allege the fact, like you're doing, while others said nothing, that they were told that if they will give a name of two witnesses, their testimony will be taken and considered. So that means that if you're trying to prove you are a citizen based upon whether your status is a foreigner, that would mean you'll be an immigrant or follow the Immigration Act or follow the Naturalization Act, because those two have nothing to do with national. nor do the 14th Amendment have anything to do with national if you're not interpreting how the 14th Amendment was supposed to be applied. Because in all actuality, the 14th Amendment has to do with national, and I say English national for a reason. All right. It says in this case, but it is said that the applicants did not prove before the immigration officer that they were citizens. That they simply alleged the fact, while others said nothing, that they were told that if they would give the name of two witnesses, their testimony would be taken and considered. But what provision of law is therefore compelling the attendance of witnesses before such immigration officers or a court or any other person, or for taking dispositions, and of what avail would it be ex parte in inquiry of such a witness? Must an American citizen seeking to return to his native land be compelled to bring with him two witnesses to prove the place of his birth, or else be denied his right to return? Remember, they're talking about American citizens identified by some type of nationality. Okay, because under the 1790 Naturalization Act, it's not based upon a nationality; it's based upon a color of skin. So must an American citizen seeking to return to his native land, natively speaking, be compelled to bring with him two witnesses to prove the place of his birth, or else be denied his right to return and all opportunities of establishing his citizenship in the court of his country? No such rule is enforced against an American citizen of Anglo-Saxon descent. And if this be, as claimed, a government of laws and not of men, I do not think it should be enforced against American citizens of Chinese descent. Okay? So as we see here in United States versus Sing Tong, it clearly shows you that Anglo-Saxons are in fact citizens based upon their ascent here in these lands. All right? And we know that Anglo-Saxon history goes back to time immemorial. And we just read the Enway Ahmad Hassan shows the distinction between the Anglo-Saxon descent here in these lands versus those nationality as declared by the Naturalization Act of 1790, which had nothing to do with descent, but of a color or complexion of skin, just like Negroes, colors, blacks, and Ethiopians. Okay? We must comprehend that. All right? Then we got, what else we got here? We got United States Juan Kimmel Art. Okay? United States Juan Kimmel Art. Let's see what United States Juan Kimmel Art is. Have you heard of that case, Brother Philip Panthlum? Because we're going to prove that based upon the 14th Amendment, when we were emancipated, that we had a choice to prove if we were free nationals or enslaved foreign nationals, now called what we call stateless people. All right? We're going to prove it by way of the 14th Amendment. Okay? With this case called United States versus Juan Kimmel Art. United States versus Juan Kimmel Art. All right? This is going to prove that English people are, in fact, nationals here in this land. Okay? I don't know about you, Brother Philip Panthlum. Lord Joe, you stated we better off doing our own research. You guys can't even work together to be on the same page. First of all, what guys are you talking about? And two, what research are you talking about? Because everyone's man knows not by being told. If a man knoweth, he must be that which he knows. All right, we are English, Anglo-Saxon Berbers. If he claimed to be a Yamasee Moors, that's fine with me. You know what I'm saying? But you are not an English national. I'm showing that the Moorish Americans, based upon the argument that they're bringing, that we were watching before I was interrupted by Philip Partham, that they are in fact foreign nationals, which based upon the laws of this land makes you a stateless person, because citizenship in North America has nothing to do with being a citizen of a country. Okay? Of a country. All right, thank you. Please don't disturb the chat. We're going to United States versus Juan Kimmel Art. a landmark decision in regards to citizenship. Okay? And this was based upon the 14th Amendment, which you claim has nothing to do with citizenship on a national level. Okay? But it was made with that, it made us what? Corporate fictions, corporate citizens, all right, or legal fictions. I'm here to prove you wrong. Okay? I'm here to prove you wrong. United States versus Warren Kimmel Art. The United States Supreme Court was held that a children born in the United States are parents of Chinese descent who at the time of birth are subject to the imperial of China but have permanent domicile residency in the United States and are carry on business and are not employed in any diplomatic or official capacity under the Emperor of China automatically became United States citizens at birth. So that means that you are employed as a citizen when you're domiciled or took residency in the United States as well as in the States. Because the only thing that determines your citizenship is the Immigration Act. If it was an Immigration Act, it would be the Naturalization Act. When Ray Hamad said that that act or statute was based upon the color of skin, which that had to do with white people. Okay? That didn't include Negroes, blacks, colored Ethiopians, so you were in fact a stateless person. The only way you can become a citizen prior to that was through Calvin's case, which had to do with those who immigrated here as foreign nationals under the Elizabeth Religious Settlement Act. All right? Then the only thing left now is what? The 14th Amendment. And the 14th Amendment had to do with those who were emancipated by the 13th Amendment, which was passed by an act of the executive branch under the auspices of Abraham Lincoln, all right, through the emancipation of slavery. All right? Now follow this, y'all. Follow this. If the 14th Amendment is such a bad thing when it emancipated us from the state of servitude as being property of the state, all right, and the Dred Scott case will validate that, which we'll go to in a second, all right, I'm going to show you that they only did to us what we did to them, okay? Follow along, everyone. Follow along. Now, a lot of us misunderstand the 14th Amendment based upon the ruling of the 14th Amendment, which had nothing to do with nationals. It had to do with foreigners, okay? The ruling was based upon foreigners, but it did not exclude nationals because when you're dealing with the 14th Amendment, it stated in the holding of that case that if you look in the box right here, the citizenship clause of the 14th Amendment must be interpreted in light of the English common law. And thus, it grants United States citizenship to all children born to alien parents on American soil with only a limited set of exceptions. They're saying a whole lot right here, y'all. They're saying is that if you are going to be a citizen here in America based upon the 14th Amendment, then that's based upon the foreign status as a foreign national, whether you came in and immigrated to the soil or whether you was born on the soil, which has nothing to do with citizenship based upon the English common law. Totally different. Totally different. So if we as black people, you know what I'm saying, misnomer, were free under the 13th Amendment and became citizens under the 14th Amendment, then the only way that we can truly be citizens is based upon us understanding English common law, because that was the supreme law of the land based upon this court case, United States versus Warren Kimmel Art. Okay, you don't believe me? A lot of us don't do the research, that therefore they lack the comprehension and the understanding of how citizenship actually works. Okay, let's go into the actual case, since we don't want to deal with Wikipedia. Let's see. I gotta warm my coffee up because this is gonna blow y'all head. And I'm pretty sure y'all knew about this case. So key points: nationals. National versus foreign nationals. Foreign nationals and nationals are two different things. If you're a national, that means you're a national of the country. If you're a foreign national, it means you're a foreign national in some other country, which means you are alien. Okay, you're pretty much an alien. And if you're neither the former or the latter, that makes you a stateless person. All right. If everyone agrees with that, let me get a thumbs up in the chat. That includes you, Mr. Philip Petham, as well as Lord Dro. If you agree with that there's only three types of status here in North America: national, foreign naturalized citizen, i.e. alien, or a stateless person. Everyone give me a thumbs up. I'm waiting. And as I'm waiting, let's read what United States versus Warren Kim Art of 1898, which is the case dealing with how citizenship is supposed to be interpreted, and that's based upon the common law of England. It specifically said the common law of England. So if you are a citizen here in North America and you claim to have citizenship here, you better know the common law of England. Okay? You better know the common law of England, because this is going to determine your fate here today. Okay? I don't care what society you're part of, what group you're part of, what clique you down, what gang you're associated with, what political group you believe in. If you're not an English national, you are in a world of trouble. Any status outside of national is irrelevant. Okay? Whether you were a naturalized citizen of the Naturalization Act of 1790, whether you became a citizen by way of the 14th Amendment, whether you became a citizen by way of the Immigration Act, or you became a citizen by way of the Religious Settlement Act. Okay? Yeah, they are in fact four. Okay? They are in fact four. Well said, Lord Dro. Let's see. Let's read it. All right? Don't get upset with the king. All right? Don't get upset with me. I'm only responsible for my nationals, according to what citizenship means under the 14th Amendment, based upon the United States versus Warren Kim Art, which we know it says in Wade versus Ahmad Hassan, and we read in United States versus Wong Kim Do that we don't have to prove that we are in fact Anglo-Saxon descendants here in America. We don't need no witnesses. We don't need no statutes. All it has to do is by operation of law, versus the other processes. Okay, very, 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 very important. It says here, the law governing citizenship. It says that there is no common law of the United States in the sense of a national customary law. You better listen to what that said. So if you are using some law that's not customary to the United States, then you're in a world of trouble. Because it just said there is no common law of the United States in the sense of a natural customary law, distinct from the common law of England as adopted by the several states, each for itself, apply as its local laws, and subject to such alterations as may be provided in its own statute. We can go to New Jersey Revised Statute, Article 22 and Article 23. We go to the New Jersey's 1844 Constitution, Article 10, Section 11, and 1947 Constitution, Article 13, Paragraph 1, Section 3. I mean, Article 11, Section 3, Article 11, Paragraph 1, Section 3. All those laws adopted the common law of England, because if it wasn't for New Jersey, no other state will have a constitution. Okay? The question was, when did England become part of North America? No, the question is when did North America become a part of England? That's a question you must ask yourself. All right? This case gonna prove it. It ain't then when did England become a part of North America? When did North America became a part of England? Because North America was here prior, British America was here prior to North America. Okay? And when British America had it, it was an empire. Okay? It was an empire. All right? So you have to know English political science, the science of government here on this land, because we're reading United States versus Warren Kim Art in 1898. And it says there is no common law of the United States. So that means that if there is no common law of the United States, then what common law was here prior to the law of the United States? It just said it. There is no common law of the United States in the sense of a national customary law because the United States is not a nation because it has no custom of its own. The custom that the United States had is the custom of the Anglo-Saxon Berber. It's as distinct from the common law of England as adopted by the several states, each for itself, apply as its local law. That means municipal law and subject to such alteration as may be provided by its own statute. There is, however, one clear exception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by this fact that its provisions are framed in the language of the English common law and are to be read in light of its history. Do everyone agree with that? So if that's the case, then how many of you know English history? Yes, it's a corporation. Through their articles in the corporation, which was created by the Constitution, which is their charter, which was the authority in which they used to incorporate based upon the corporate domicile, which is what we call now Washington, D.C. Like any other state, wherever they located at, their primary place of doing business, that determines the citizenship as well as the citizenry. All right? Let's see. The fundamental principles of the common law with regard to English nationality was birthed within the allegiance, also called legality, obedience, faith, or power of the king. The principle embraces all persons born within the king's allegiance and subject to his protection. Such allegiance and protections were mutual as expressed in the maxim protectio transit subjectionem et subjectio protectionem, and were not restricted to natural born subjects and naturalized subjects, or to those who had taken an oath of allegiance, but were predicable of aliens and amity so long as they were within the kingdom. 1 second. Okay. Such principles embrace all persons born within the king's allegiance and subject to its protection. Such allegiance and protections were mutual as expressed in the maxim protectio transit subjectionem et subjectio protectionem, and were not restricted to just natural born subjects, all right, natural born subjects and naturalized subjects, or to those who had taken an oath of allegiance, but were predicable of aliens in amity so long as they were within the kingdom. Children born in England of such aliens were therefore natural born subjects, but the children born within the rim of foreign ambassadors or the children of alien enemies born during with their hostile occupation of part of the kingdom's dominion were not natural born subjects because not born within the allegiance, the obedience, or the power, as would be said at this day, within the jurisdiction of the king. Did y'all hear that? Y'all heard it, but did you understand that? This fundamental principle with these qualifications or explanation of it was clearly, though quantity, stated in a leading case known as Calvin's case. You hear that? Calvin's case was a case of post deny. All right, those who will be subject under the authority of the British Parliament, known as Great Britain, that was established in 1707 through the Treaty of Union. We must comprehend that. All right, we must comprehend that. Now let's go back to the lecture.
Oregon, Supreme Court case law, 366 U.S. 187 194 81 SCT 922 1961 was the year. Reads, a state cannot refuse to give foreign nationals their treaty rights because of fear that valid international agreements may possibly not work completely to the satisfaction of state authorities. Under the Supremacy Clause of the United States Constitution, Article 6, Clause 2, state policies as to the rights of aliens to inherit must give way to overriding federal treaties and conflicting arrangements. Conflicting arrangements. This writ of habeas corpus is a conflicting arrangement to the state policies of Charles County District Court and the state of Maryland Incorporated. Both of them are incorporated, right? That conflicts. However, state policies are overridden with federal treaties and conflicting arrangements. So moving forward, on or about March 10th, 2021, the defendants were served at their present addresses, either personally or through their agent, with the writ of habeas corpus as justiciandum and the affidavit of evidence and information in support of the writ of habeas corpus as justiciandum, with attachment Exhibit A1. There has been no cause to the contrary made thereto by the defendants. As of this date, the defendants have failed to execute their obligation in the writ of habeas corpus as justiciandum, which constitutes default and breach of duty, while being kidnapped and held hostage for profit at the foreign Charles County Detention Center, Inc. Our Moorish American national, Jabal LL, has been subjected to inhumane treatment, which includes being denationalized, being held to the conditions of slavery, connotatively speaking, and involuntary servitude, being compelled to eat genetically modified organisms, GMOs, and drink contaminated water in order to stay alive, and being denied phone access to his relatives, loved ones, and consular, per consular notification requirements. As a result, the defendants are in violation of Articles 6, 20, and 21 of the Treaty of Peace and Friendship of 1836 between the United States of North America and the Moroccan Empire. Also,
Stop. Let's stop right there. And let's go right back here. And show them your first problem. The affirmative defense arises under Article 3, Section 2, Clause 1. All right. Suits affecting ambassadors or public ministers and consuls, which you can clearly see that the lecture involving the consular Maurice L. claims to be an ambassador. All right. So if you're an ambassador, that means you're acting in some capacity under the political government. All right, acting on behalf of the citizens. All right, which is a public office. All right. Remember, people change, but positions don't. All right. So Section 2, Clause 1 states that the judicial power shall extend in all cases in law and equity. All right. Arising under this Constitution and the laws of the United States and treaties made or which should be made under their authority to all cases infecting ambassadors or public ministers or consuls, which they claim to be. To all cases affecting admiralty and maritime jurisdiction, which is that's the jurisdiction in which the case they're bringing should be heard in. Okay, involving matters concerning admiralty and maritime jurisdiction, because you really don't have the right to be on the land and bring up claims involving the land, involving claims based upon commerce on the land, because that's trespass. Okay, You're trespassing. That's an intrusion of seclusions of those rights of the English people who have the right to be over here as true nationals, as well as the rights to the property here as nationals, because they are truly, in fact, citizens. Why? Because they are citizens based upon the supreme law of the land, which is the common law of England, which was incorporated in every state based upon their constitution, which was not a charter to do power or authority, but was a charter of what we call limitations. Okay? It was a limitation of what they could do on their land that was given to them based upon a land grant, because a land grant is a charter. It's called a fief. Okay? A fief. To even have the right to representation here in the civil government, whether it's criminal or civil, you must first be a citizen. Okay? To act as the consular or administrative officer or an ambassador, you first must be a citizen. Okay? You're not over in Morocco acting on behalf or representing on behalf of the citizens of which is in question. You're over here in North America acting on behalf of a citizen which is in question based upon his status as a citizen being a foreign national. And as we see it in Writ Hamad, the Arabs were not considered citizens in the meaning and the interpretation of the Naturalization Act of 1790. Nor were they citizens in the meaning of the Act of the Immigration Act. Nor were they citizens in the meaning of the Act of the 14th Amendment, because that was interpreted by what? The common law of England. It's very important for you to understand that, because that was your window of opportunity. Why? Because slavery was brought over when Britain was established and passed on to what we call North America through the Treaty of Paris of 1783. Okay? We must comprehend these inexcusable, neglected, wasted facts at law. So in order to even bring an issue on the right that you have here in North America, you must bring it under this: between a citizen of the same state claiming lands under grants of different states, because the state of Maryland is a different state than the state of the incorporated state of what we call Moors or Morocco, or whatever name or term you choose to use based upon your certificate of incorporation, which sets the standard for its citizens based upon their state of incorporation. So you have not solved that problem, because they are considered residency as a result of their oath of allegiance as foreign nationals to a country that's subject based upon the national standards as defined by the statute Title 8, which is nothing more than based upon an oath of allegiance. A oath of allegiance. If you taking an oath of allegiance as Joachim Ark stated, then you better be listening to your king right here. You better be listening to your king right here. It's very important that you comprehend what it is that I'm saying to you, because your very status may depend upon it. Okay? How? Let's go back to them for a little bit more.
Also wanted to add article, I believe it was 16, where it says the prisoners should not be made as slaves. Article 16 of the treaty, that is. And Article 3, Section 2, and Article 6, Clause 2, and Amendments 1, 4, 5, and the organic 13th Amendment, Section 12 of the Constitution for the United States of North America. This is the order. Wherefore, it is therefore considered ordered in a judge that an order of default be, and the same is hereby entered against the defendants. It is further ordered in a judge that the defendants are in breach of their duty by failing to execute their treaty obligations under Articles 6 and 20 of the Treaty of Peace and Friendship of 1836 between the United States of North America and the Moroccan Empire, and the Supremacy Clause of the Constitution for the United States of North America under Article 6, Clause 2, and have therefore forfeited any and all offices, oaths of office, and surety bonds in relation to any alleged public service and or office of trust.
Stop.
Claimed by the
Stop. Let's stop right there. Office of trust. And the trust which they're talking about is, in the eyes of those who don't know what they're talking about, it's called a cess to que. Okay? A cess to que. Brother Philip Partham II, you made two comments, all fake, and then you made another comment, brothers misleading y'all. Who are the brother you talk? Who is the brother you talking about? Please clarify that. Once again, Philip Partham II, you stated all fake and brother misleading y'all. Who are you referring to as the brother who is misleading the people? Well said, Lord Joe. I'm waiting for your comment, Philip Partham. All right, we already see where you're going with that. He's an upset brother. We're just going to continue to go on. How are you misleading the people? When the very people are misleading is the one we're talking about right now.
defendants are under color, tongue twister, under color of any law. It is further ordered and adjudged that in accordance with Articles 20 and 24 of the aforesaid Treaty of 1836, which we will go over, a writ of warranto shall be issued under consular jurisdiction by this Morocco Consular Court and against the defendants to inquire by what authority under the Constitution for the United States of North America are the defendants exercising the judicial power and jurisdiction of the Republican form of government, because there's only one form of government on this land.
Well said, Archbishop. Okay, so the main argument that the Consular Maurice Elder is making is based upon a core warranto, all right, which is a writ that didn't originate under Morris political science. It originated under English political science, but they are not English heirs, okay? They are not English heirs, okay? They're trying to escape the bondage of the political science that was created by the government now called America, or the states of Maryland, or any other state for that matter. They're trying to get from under the encumbrances that were created based upon the status of citizenship, okay? As them being foreign nationals here. So they're trying to change their status from being a foreign national here to becoming a national here in the United States, okay? And the rights as nationals here in the United States based upon the laws of the country that come from some other country other than the United States. Okay, so how am I misleading the people if I'm bringing out these questions that no one is deemed or fitted to ask? All right, so let's leave from these brothers and address what they're not addressing, okay? Let's go to the Dred Scott case. This is the Dred Scott case. Dred Scott versus Sanford. All right, everyone familiar with that case? Sorry, you had to be removed, brother Patham, if that is your real name. All right. Dred Scott versus Sanford. To the position that slavery can only exist except under the authority of law, it is objected that in few, if any instances, has it been established by statutory enactment. This is no answer to the doctrine laid down by the court. Almost all the principles of the common law had their foundation in usage. All right. Slavery was introduced into the colonies of this country by Great Britain. It didn't say England. It said Great Britain. Great Britain was established in 1707, well after English was started. English goes back to the time of Alfred the Great. All right. And we know Alfred the Great was those who were the wise council known as Witten or Wittenmont, which according to the 1911 encyclopedia, written by those who were the kings of Great Britain, i.e. the Scottish minor, said that the government that was then at that time was called the government of the Anglo-Saxon burghs. Okay. It said there is no answer to the doctrine laid down by the court. Almost all the principles of the common law had their foundation in usage. Slavery was introduced into the colonies of this country by Great Britain at an early period of their history, and it was protected and cherished until it became incorporated into the colonial policy. Did you hear that? So how am I misleading people? It is the immaterial whether a system of slavery was introduced by express law or otherwise, if it had the authority of law. There is no express law or otherwise. There is no slave state where the institution is not recognized and protected by statutory enactment and judicial decisions. Okay? Slaves are made property by the laws of the slave states, and as such are liable to the claims of the creditors. They descend to heirs, are taxed, and in the South they are subjects of commerce. Did you hear that? I didn't write this. Where was that at? Where will it go? I lost my place. 1 second. How did I lose my spot that quick? Let me just find it, y'all. This is a long case. Okay, that's it. Okay. All right. Now it states, I will now consider the relations which the federal government bears to slavery in the state. So it said that slavery was incorporated in the colonies by Great Britain. It said that in this case. Now we're talking about the impact that slavery on the federal level has on the state level. Okay. It says, I will now consider the relations in which the federal government bears to slavery in the states. Slavery is emphatically a state institution, and the ninth section of the first article of the Constitution, it provided that the migration or importation of such persons as of any state now existing shall think proper to admit should not be prohibited by the Congress prior to the year 1808, but tax or duty may be imposed on such importation not exceeding $10 for each person. So slavery was regulated in all states. You hear that? In all states, including New Jersey. Okay? Including New Jersey. Let's go a little further. The provision in regard to the slave trade shows clearly that Congress considers slavery a state institution to be continued and regulated by its individual sovereignty, and to conciliate that interest, the slave trade was continued 20 years, not as a general measure, but for the benefit of such states as shall think proper to encourage it. Do you hear this, y'all? Do you hear this? Many of the states on the adoption of the Constitution or shortly afterward took measures to abolish slavery within their respective jurisdiction. It is well known fact that a belief was cherished by the leading men, South as well as North, that the institution of slavery would gradually decline until it would become extinct. The increased value of slave labor in the culture of cotton and sugar prevented the realization of this expectation. Like all other communities and states, the South were influenced by what they considered to be their own interests. But if we turn our attention to the dark ages of the world, i.e., the dark ages, i.e., the Middle Ages, it states why confine our view to color slavery. On the same principles, white men were made slaves. All slavery has its origin in power and against rights. Okay? So back in the dark ages of the world, not just the state, not just the county, not just the municipality, not just the country, but the world. All right? It said that they were enslaved. Because we know that their citizenship was based upon complexion of a skin. All right? We must comprehend that. So for us to not fall into that category, we must look upon the descent from Juan Kimmel Ark in regards to citizenship as established in lieu of what we call the 14th Amendment. In closing, United States versus Juan Kimmel Ark. The law of England in almost all civilized countries ascribe to each individual at his birth two distinct legal states or conditions, one by virtue of which he becomes the subject of some particular country, binding him by the tie or natural allegiance, and which may be called his political status, another by virtue in which he has ascribed to him the character of a citizen of some particular country, and as such is possessed of certain municipal rights and subject to certain obligations, with latter character is the civil status or condition of the individual and may be quite different from his political status. Do y'all hear this? Do y'all hear this? And then, while maintaining that civil status is universally governed by the single principle of domicile or domicilium, the criterion established by international law for the purpose of determining civil status and the basis of which the person's rights of the party, that is to say, the law which determines his majority or minority, his marriage, succession, testacy, or intestacy, all right, must depend. And yet distinctly recognize that man's political status, his country, i.e. patriarch, and his nationality, that is natural allegiance, may depend on different laws in different countries. He evidently used the word citizen not equivalent to subject, but rather to inhabitant, and had no thoughts of impeaching the established rules that all persons born on the British Dominion are natural born subjects. Okay? Natural born subjects. Lord Chief Justice Cockburn in the same year revealing the whole matter stated By the common law of England, every person born within the dominions of the crown, no matter whether or of English or of foreign parents, and in a later case, whether the parents were settled or merely temporarily sojourning in the country, was of English subject, save only the children of foreign ambassadors who were except because of their fathers carried their own nationality with them, or the child born to a foreigner doing hostile occupation of many parts of the territories of England. No effect appears to have been given to the descent as a source of nationality. You hear that? Do you hear that? All right. So you have a choice to make. All right. Because we know United States versus Wynkoop Art was the case that established how citizenship was to be determined here in North America on the federal level and the state level. Okay? On the federal level and the state level. And United States versus Wynkoop Art, which we just read, the case or quoted from the case, the primary ruling of the case stated that citizenship clause of the 14th Amendment must be interpreted in light of the English common law. The only person that has anything to do with the 14th Amendment was, in lieu of being citizen here on this land, and not those who dealing with immigration, was those people identified or classified as stateless person, as Negro, Black, colored, Ethiopian, and apparently that's Moorish American too, because Moorish American are not citizens based upon that as known under the English common law. And let's go back to the English common law in closing. English common law encompasses criminal and civil justice. Okay? Criminal and civil justice. That's the common law of England. All right? English common law is the common law legal system of England and Wales, comprising mainly of criminal law and civil law. Each branch having its own courts and procedures. These are called assize courts. Okay? Assize courts. Legal terminology deals with criminal law and civil law. Common law and civil law. Okay? Common law and equity. In the context, common law means the judge-made law of the king's bench, whereas equity and the judge-made law of the courts of chancery, which we'll review in a second based upon case law. Okay? Based upon case law. Where are we at? Let's go here. And we go back to the cases we reviewed yesterday in closing. Birch versus Hingley. Okay? Birch versus Hingley. New Jersey State Court claim dealing with special civil and landlord tenant. All right? New Jersey statute annotated 2A65-3 is a statute incorporated under the common law of England, incorporated into New Jersey's law by Governor William Patterson. Okay? All right? Involving criminal and civil justice, which is governed under New Jersey Revised Statute 2A, or statute annotated 2A, dealing with waste or trespass under the common law in regards to English property. All right? Right here. New Jersey Revised Statute 2A65-3, which you see right here, was incorporated by way of ancient statutes that derived from England, known as the Statute of Gloucester, Marlingborough, and Westminster's, which was incorporated by Governor William Patterson. The section of our revised statute on which complainant relies on, and this complaint we're reading in 1999 in the Special Civil Parts Superior Court in Monmouth County, relatively speaking, it says the section of our revised statute on the complainant relies on a relic of the Middle Ages taken from the Statute of Gloucester of Edward I, enacted by Governor Patterson, following the statute of Gloucester and other ancient English statutes known as the Statute of Westminster, and the prevention of concerning the prevention of waste, which passed by the legislature March 17th in 1795. His statute has retained a place in our hooks, with the minor changes now appearing under Title II of the revised statutes under Article 1, Chapter 79. It also says it's in Kinlow Corp versus Isolated Type Incorporation, which I recite in closing. This is a Chancery Court in 1946. Complainant owns premises in Belleville, which are the possessions of defendants under a lease or a term years made by the complainant's predecessor in lieu of a title. The bill charges that defendants has failed to failed to keep the demise building in repair and has suffered it to become dilapidated. The decree is prayed. One second now. Okay, so complainant owned premises in Belleville which are in the possession of defendant under a lease or a term years made by the complainant's predecessors and title. So somebody else that exists before the complainant left something to be conveyed in lieu of what we call a title or a deed, in lieu of a tenant, and the tenant has caused waste to the property as a result of it being being that it was being overseen by the tenant in possession. The bill charges that the defendant has failed to keep the demised building in repair and has suffered it to become dilapidated. This is where you get into foreclosure. A decree is prayed that the defendant paid rights of damages to be assessed for the waste and that the defendant shall lose the premises, i.e. by being ejected, and the tenancy be terminated. On filing the bill, council moved that a writ of waste issued pursuant to New Jersey Revised Statute 2:79-3, which has now been amended or subjugated by 2A:65-3, which does waste. A complainant may bring a waste complaint and be paid treble damages. It states any person who have a writ of waste out of chancery against any person holding by dowry, courtesy, or otherwise for life for the term of years, i.e. fee simple or other terms, as well as against a guardian, and whoever shall be convicted of waste shall lose a thing or place wasted and shall be liable of thrice damages accessed against him by a jury. It states that the section of revised statute as quoted in as quoted in Burt versus Hanley, they state that the section of revised statute on which the complainant relies is a relic of the Middle Ages, and Governor Patterson has incorporated those relics, i.e. those statutes, in present day statute 2A:65-3. All right, and it goes on to say that, as it says in Burt versus Hanley, that it was the principle of the English law that no action could be maintained in the King's Bench or courts of common pleas without the sanction of the King's original writ, whether it was a writ of habeas corpus, a writ of warranto, a writ of prohibition, a writ of circulator. That writ must come from the King's Bench and not from some consular claim to be an ambassador doing foreign relations on behalf of foreign people, foreign nationals. It states in closing that it was the principle of the ancient English law that no action could be maintained in the King's Bench or common pleas without the sanction of the King's original writ, which issued out of chancery as the officio justicat, and which gave to the law court's jurisdiction of the cause, meaning the court have jurisdiction to hear the matter. The writ ran in the King's name. There are no king, and directed the sheriff, which there are no sheriff, to command the defendants to appear in the King's Bench or the common pleas. They are not the King's Bench, nor is that a court of common pleas, nor are they officers denoted to the sheriff, nor they are the king. Okay, so it says the writ ran in the King's name and directed the sheriff to command the defendant to appear in the King's Bench or the common pleas as the case might be, and and there to answer the complainant, which was briefly stated in the writ. If the defendant failed to obey, process known as judicial writs issued out of law courts to compel his appearance, in which are several specimens of original writs, which is the one we just mentioned. Okay? Very, very, very important to comprehend what's going on. What happened? Okay. So in closing, all right, in closing, I'm going to leave out on Chittum versus Jordan. No, do I want to read that? Yeah. This is for my brief. My brief. This is a brief that I wrote for the civil action in lieu of the motion hearing that should be originated sometime toward the end of the month. This matter had come before the court by the King Clifford Jefferson, and the court having read and considered the papers submitted with respect thereto and papers filed in opposition thereto, and other good causes have been shown for the entry of the written order pursuant to New Jersey Fire Statute 47:1A-1, which is the law governing the public record, which has the right to be examined by a citizen in regards to the entrusted obligation that all officers have in regards to the expectancy right and privacy of those who are filed for the record pursuant to citizenship, which we have declared for the record. All right? The public record is governed under 47:1A-1, which states that all government records should be subject to public access unless exempt from such access as required by the Public Record Act, as amended and supplemented in any other statute, resolution of either both houses of the legislature, regulation promulgated under the authority of any statute or executive order under the governor or any officer acting in that capacity, or any rules of the court, or any federal law, state law, federal regulation, state regulation. A public agency has a responsibility and obligation to safeguard, have an obligation, all right? Where we at? The public agency have a responsibility and an obligation to safeguard from the public assets a citizen's personal information, which it has been entrusted when disclosure thereof would violate the citizen's reasonable expectation of privacy, and nothing contained and amended and supplemented should be construed as affecting in any way the common law right of access to any record, including but not limited to criminal investigatory records of the law enforcement agency. So this is what those consulars should have been raising based upon the public record, which is based upon the expectancy of privacy rights that they claim to have as foreign nationals filed for the public record. Okay, but there is no such expectancy right filed for the public record because you're not considered a national in their eyes. Okay, very important that you comprehend that. Preliminary statements with statutory citations. Plaintiff, as King Clifford Jefferson, brings a civil lawsuit against the state of New Jersey after being arrested and charged with a false government identification card issued by the state of New Jersey and Department Motor Vehicle Commission under the Real ID Act of 2004, which violates the plaintiff's First, Second, and Third, as well as Seventh Amendment rights. And Seventh Amendment right, which means unlawful search and seizures, and the people have to be a right to be protected in persons, houses, and effects, as well as documents which was filed for the public record, which they violated. By my own admission, I, King Clifford Jefferson, has filed this action purely to serve as an affirmative defense to those pending criminal charges filed in the criminal court being heard on January 9th, because the court date was removed, parts of December 9th, removed from this Friday to December 9th of that month. Okay, under the MID docket number 000889. While the operative pleading seems vague to the defendants as well as to everyone who don't comprehend English political science, which is not by chance, they willfully admit, and I willfully admit, that even if the court was to accept all the factual allegations contained therein as true, which it must do at this stage of the proceeding, it will be apparent to the court, based upon this opposition, that King Clifford Jefferson's amended complaint should not be dismissed for what? These several reasons. Let's see what these several reasons are. First, to the extent that the defendants assume that such claims warrant dismissal because I have not filed the requirements by filing the complaint under the New Jersey statute annotated under Title 59. Title 59 is governed dealing with New Jersey's what we call Civil Rights Act, all right? And which they also claim immunity under Title 59 governing the Civil Rights Act. So if you claim immunity under the act that protects our civil rights, then that Civil Rights Act that you passed and what you got immunity of is unconstitutional. All right, because you are committing fraud and have immunity as a result of the statute that you created to commit the fraud. All right, we must comprehend. All right, what statute did they create to commit the fraud? All right, that's the New Jersey by statute 39-3-29.3, which is the law governing the unconstitutional instrument that you use as a standard driving license or a motor vehicle driving license. Okay, which we go to in a second. Second, defendant's dismissal is not appropriate because pursuant to Title 59, which they claim to have immunity under, all right, it says under that same statute 3-14 of Title 59 that nothing in this act shall exonerate a public officer from liability if it has been established that his conduct was outside the scope of his employment or constitute a crime, actual fraud, actual malice, or willful misconduct. Okay? Under the same statute 3-4, it also states that you will have no immunity and you will not be exonerated based upon your immunity if a public employee acts under the apparent authority of a law that is unconstitutional, invalid, or inapplicable. He is not liable for an injury caused thereby, except to the extent that he would have been liable had that law been constitutional or valid and applicable. Okay? The common law is applicable and valid, and as a result of that, you are held reliable because you have committed fraud by violating the common law of England, which protects my right as a citizen based upon my status as a citizen. Why? Because the standard identification card you use that does not denote the citizenship, that's the instrument you use to make the unlawful arrest, which was a violation of my First, Second, and Third Amendment right as a result of you violating my Seventh Amendment right, which is violation of improper search and seizures. Okay? How is it improper search and seizures? The statute says why it's improper search, and seizure. Okay? Let's see. Third, the defendants have used a standard identification card issued under the Real ID Act of 2005. And if you pull it out of your pocket, and it says right on the face of it that is not for ID purposes, which is clearly fraudulent instrument used to identify plaintiffs or defendants in matters brought before a court of law based upon the guise of an actual what we call a trespass claim. Okay, because they claim you broke the peace of the state. All right. So it says that 39:3-29.3 is the statute governing the standard identification card or the motor vehicle driver license, which is clearly a fraudulent instrument used to identify anybody, which violates the due process rights of anybody who claims to be a citizen of any nation, including those who are subject of England. Here, in this particular Anglo-Sphere, the defendant's motion is based upon a statute and regulation promulgated pursuant to the statutes which are unconstitutional or invalid. Okay. Why? Because it says that the New Jersey by statute governed under 39-3-29.3 governing that document, which you call a standard identification card, i.e. a motor vehicle driver license, it states that any document and personal information, including an applicant's photograph obtained by the commission, i.e. DMV, from an applicant for a standard identification card shall be confidential, meaning between them and you, and should not be considered a part of the public record pursuant to 47:1A-1. If you have the right to access to the public record and that standard ID has nothing to do with the public record, that means that you're not a citizen. You're some type of citizen because citizens denotes two status, but not the status of a national or foreign national, because that's governed under Title 8. All right? And the citizenship, according to the registry given by the standard instrument called a driving license, has nothing to do with Title 8 because it just said it. It says that it should be confidential and not be considered part of the government record pursuant to the public record statute 47:1A-1, which you have the right to, if you're a citizen, to examine it based upon the expectancy and privacy right that they are entrusted to protect, or the common law. So that means the standard ID has no affiliation under the common law. That's why you're not a citizen, because when they passed the 14th Amendment, citizenship is supposed to be determined under the common law of England based upon United States versus Warren Kimmel Art. Do everyone agree with me? If you do, please give me a thumbs up on the chat right now. So it says, or the common law concerning access to government record and should not be disclosed by the commission for any purpose. That's why it says on the ID that is not for ID purposes, because it says right there that under Title 8 of the United States Code governing citizenship of nationals and foreigners, it says that instrument is not to be used for any purposes related to Title 8 United States Code without the informed consent of you, the applicant, or a warrant signed by a state or federal judge or a lawful court order or subpoena, except that nothing in this section should be construed or to prohibit or in any way restrict any action where such prohibition and restriction would be contrary to federal or state law. I'm still waiting for my thumbs up, everyone. I hope y'all ain't falling asleep. Wake up, y'all. Possession of a standard identification card issued pursuant to this section should not be considered evidence of an individual's citizenship or immigration status and should not be used as a basis for an investigation, arrest, citation, prosecution, or detention. Page 2 through 4 of opposition. Okay? Corporate domicile. Corporate domicile refers to a place where a company's affairs are discharged. It is also known as a legal home of the corporation because the place is considered by law as the center of its corporate affairs. Corporate domicile is a place where a company principal affairs of business are maintained. A corporation is considered a citizen of both its state of incorporation and the state of its principal place of business. Corporate domicile helps in ascertaining the legal status of a corporation. Corporate domicile also helps to ascertain taxes on companies. You must understand that. All right. A permanent resident is the United States is an individual who has been granted the right to live and work in the country indefinitely as a citizen. So it means you were employed to be a citizen. You ain't even getting paid for it. Versus those who were born here by blood, because a citizen has either been born in the country, i.e. foreigner, derived or acquired citizenship through a parent by blood, or have gone through the naturalization process, which the standard ID, driver license, or any other instrument called a birth certificate does not measure up to. Okay? So as a result of that, the criminal offense and the civil complaint should be warranted based upon my argument. Why? Because I'm obligated and justified by what I'm obligated to do as justified as a necessity by law, because the law requires it. Why? Because under the criminal statute, under 2C colon 3-3, the charges you charge me with are justifiable. Why? Because under 2C 3-3, which is the laws created under 2A, which deals with criminal and civil justice, which was passed by our forefathers, 1, the law defines the duties or functions of the public officer or the assistance to be rendered to such officer in the performance of his duties, or 2, the law governing the execution of the legal process. That's the common law of England. That's the laws governing the common law of England and the actions of those who act in the capacity under the common law of England to act in the fiduciary duty, which is a necessity, which may be offensive to those, but is also justified. Let's prove that. Under New Jersey Revised Statute 2C:3-2, which deals with the criminal statute, what they charge me under, but the statute they charge me under also provides a remedy, because law does provide a remedy. So the reason why I was arrested, it became offensive to them because they didn't realize that I was acting in the public office based upon the law that allows me to act in that corporate capacity. Remember, people change, but positions don't. Okay? People change and positions don't. The necessity of the ability to act in my official capacity under the law require me to do so is a necessity that's governed under New Jersey Revised Statute 2C:3-2, which states that conduct which will otherwise be offensive is justifiable by reason of a necessity to the extent permitted by law, and as to which neither the code nor other statutory law defining the offense provides exception, i.e. a remedy, or defense dealing with the specific situation involved in a legislative purpose to exclude the justification claim does not otherwise plainly appear. Okay? So as a result of the laws that you're using, it becomes offensive for you because your laws that you use to justify your actions is not the common law of England, but the common law of England that I use to justify my actions are, even though it's offensive to you, it's of necessity to us. Why? Because the law requires it based upon the office that I hold. If everyone understood that, please give me a thumbs up in the chat. Okay? Please give me a thumbs up in the chat. So based upon 2C:3-2 of New Jersey Revised Statute governing the criminal code, the necessity, conduct which would otherwise be an offense is justifiable by reason of necessity to the extent permitted by the law, and as to which neither the code nor other statutory law defining the offense provides exceptions or defenses dealing with the specific situation involved any legislative purposes to exclude the justification claim and does not otherwise plainly appear. Or B, other justification in general. Conduct which would otherwise be an offense is justifiable by reason of any defense of justification provided by law, but which neither the code nor other statutory law defining the offense provides exceptions or defense dealing with the specific situation involved in a legislative purpose to exclude the justification claim and does not otherwise plainly appear. This is called an affirmative defense. An affirmative defense. I know I'm talking fast, but I had you guys here for a while. I'm trying to speed this up. So based upon my affirmative defense as a citizen of England and a representative of the nation as king, and contrary to the opposing party, which is a diversity issue based upon the state of New Jersey or any state within the union that make up the United States, based upon the common law of England, which is incorporated in every state's constitution, which is based upon the indefinite government that existed prior to the temporary or ceremonial government that they have now, especially those that talk about with New Jersey. It clearly says here, the defendant's corporate domicile, i.e. their place of business, which determines their legal status based upon the business purposes and intent through their articles of incorporation, i.e. their charter, all right, involving a citizen, involving some type of land grant, involving the citizens and the right for remandment or reversion of their estate in lieu of what we call foreclosure, which is a steep power, not of the state, because the power of the state in lieu of its treatment is called a bona vacatina. They only look over the property because it was abandoned because there's no one to retrieve it based upon how the law provides so, and that's called the law of interstate. When the laws of interstate, that means that when there's law property abandoned where it's real property or personal property, it reverts back to the crown as part of the crown's jewelry gallery. Okay? I'm smooth with this. New Jersey Revised Statute 52:1-1 clearly states the state of New Jersey, by way of its corporate domicile, sets the limitations upon the citizens who become citizens of the state of New Jersey based upon their residency as a citizen and what you were employed to do. Okay? That's New Jersey Revised Statute 52:1-1. All right, it might be different in your own state based upon the state in which your state incorporated, but nonetheless, it still denotes to the same status. Okay, it denotes to the same status. all govern under their state constitution, under the laws that govern their continuity of the government, what they so-called say they're acting under. And New Jersey is based upon paragraph 6, section 4, article 4, and paragraph 4 of section 4, article 4 of New Jersey Constitution, which is based upon the continuity of government, which is based upon joint resolutions and bills. Okay? Not legislation and the Constitution. Let's read it. Section 4. Each house shall keep a journal and its proceedings, and from time to time publish the same. The yeas and nays of the members of either house on any question should be or demand of 1/5 of those present to be entered on their journal. I didn't mean to read that one. Let's read right here. Paragraph 6 and paragraph 4 of Article 6, Section 4. Paragraph 6 of Section 4 of Article 4, or for the purpose of ensuring the continuity of the government operations of paragraph 4 of Section 4 of Article 4 of the Constitution of the State of New Jersey, okay, which is based upon joint resolutions and bills, okay, joint resolutions and bills, all right, we must comprehend. Any bill or joint resolution that they create by way of an act of legislation is unlawful because they have not complied with Section 1 of the Constitution. It states that the legislative power is to be vested in a Senate and General Assembly. No person shall be a member of the Senate who shall not have attained the age of 30 years and have been a citizen and resident of the state for 4 years and of the district for which he shall be elected 1 year next before his election. So they have met the requirement based upon residency, based upon them being employed in the state in which they're incorporated, but they have not measured up to the status of citizenship on a national level. If that makes sense to everyone here, or who will be watching this, or who are ignoring this lesson, please give me a thumbs up in the chat. So in closing, I'm going to draw from Chisholm versus Georgia, which is applicable in New Jersey as well because the 11th Amendment superseded Chisholm versus Georgia, but only if the states amended their state's constitution in lieu of the 11th Amendment, okay? Where it says that the states cannot be sued in the district court because they have immunity. This case does not affect the state of New Jersey, all right? You must comprehend. 3 questions that were posed in this case involve 3 questions. Can the action of trespass be brought against the state? All right? Can the action of trespass, which is called the action of assumption, be brought against the state? When you trespass, it's a part of what we call invasion of privacy, which is an intrusion upon who we say we are. Invasion of privacy is an intrusion upon your seclusion, your private space as a citizen, all right? 2, whether a state can be, in any case, instance, be sued. And 3, can a state assume, meaning presume? All right? Very important. Right here. I'm going to close that on this. Thank you, Lord Troll. The Constitution therefore provides for the jurisdiction wherein the state is a party in the following instances. First, controversy between 2 or more states, i.e. corporations. 2, controversy between a state and a citizen of another state. That means the citizens of a state and citizens of another state. 3rd, controversy between the states and foreign statuses, citizens or subjects. And it also provides that in all cases in which a state should be a party, the Supreme Court should have original jurisdiction. All right? But none of these are dealing with issues involving matters concerning the land, as in Section 5. All right? Which specifically speaks to it. The question, as I before observed, is will be an action of a sumpit lie against a state. If it will, it must be in virtue of the Constitution of the United States and of some law Congress conformable thereto. The part of the Constitution concerning judicial power is as follows. Article 3, Section 2. The judicial power shall extend 5. To controversy between two or more states, between a state and citizens of another state, between citizens of a different state, between citizens of the same state, claiming lands under grants of different states. That is the issue. The Moors or the consular generals that we just read in the lecture are not dealing with any issue in regards to your citizenship or status as a national here under a land grant, because a treaty is not a land grant. Once again, a treaty is not a land grant. All right, so in lieu of that, let's go to page second, 4, section 435 of the case. In Chilton versus Georgia. The only principle of law, then, that can be regarded as those commonly to all the states. I know of none such which can affect this case, but those that are derived from what is properly termed the common law. A law which I presume is the groundwork of the law in every state in the Union, and which I consider so far as it is applicable to the peculiar circumstances of the country, and where no special act of legislative controls it, to be enforced in each state as it existed in England, unalterated by any statute at the time of the first settlement of this country. Y'all better listen to me. The statutes of England that are enforced in America differ perhaps in all states, and therefore it is probable the common law in each state in some respect is different. But it is certain that in regard to any common law principle which can influence the question before us, no alteration has been made by any statute which can occasion the least material differences or have any material effect, any partial effect. Any partial effect. No other part of the common law of England, it appears to me, can have any reference to this subject but that part of it which prescribes remedies against the crown. Every state in the Union, in every instance where its sovereignty has not been delegated to the United States, I consider to be a complete sovereign, as the United States are in respect to the powers surrendered. The United States are sovereign as to all the powers of government actually surrendered. Each state in the Union is sovereign as to all the powers reserved. It must necessarily be so because the United States have no claim to any authority but such as the states have surrendered to them. You must comprehend that. Point 437 of this case. Point 447. Oh no, let me go back up. I missed something. Point 437 of the same case. Now, I presume it will not be denied that in every state in the Union, previous to the adoption of the Constitution, the only common law principles in regards to suits that were in the manner admissible in respect to claims against the state were those which in England applied to claims against the crown. You hear that? There being certainly no other principles of the common law which previous to the adoption of this Constitution could in any manner or upon any color apply to the cases of claims against a state in its own courts, where it was solely and completely sovereign in respect to such cases at least. Whether that remedy was strictly applicable or not, still I apprehend that there was no other. The only remedy in a case like that before the court by which by any possibility a suit can be maintained against the crown in England or could be at any period from which the common law as enforced in America could be derived, I believe is that which is called a petition of right. It is stated indeed in Commentary Digest, Common Digest 105, that until the time of Edward I, the king might have been sued in all actions as a common person, and so authorities are cited for that position, though it isn't even there stated as a doubt. But the same authority adds, but now none can have an action against the king, but one should be put to sue to him by petition. New Jersey by statute 46:30B1, New Jersey by statute 46:3-2, New Jersey by statute 46:3-5, 46:3-15, and 46:3-10. These are New Jersey revised statutes in regard to claims that can be brought forth by a claim by the king in regard to property that rightfully belongs to the king as a result of it being allodial land. And if it's allodial, that means there are no feudal tenures on the land and everything should be in free and common soakage as established by the citation as recorded here on the record for the public record. Okay? Point 440 of this case. Let's read. By all these authorities and by many others which I could cite, both ancient and modern, it is plain that if the subject was to recover rent or annuity or other charge from the crown, whether it was a rent or annuity originally granted by the king or issued out of the land, which a subsequent title came to be in the king's hand, in all cases, the remedy to come at it was by petition to the person of the king. Did you hear that? We got another fool, Barrington Edwards, Archbishop Blockham. All right, so it goes on to say, for all these authorities, and by many others which I could cite, both ancient and modern, it is plain that if the subject was to recover rent or annuity or other charge from the crown, whether it was a rent or annuity originally granted by the king or issued out of a land which by subsequent title came to be in the king's hand, and in all cases the remedy to come at it was by petition to the person of the king, and no other method can be shown to have been practiced at the common law. Okay, at the common law. So Barrington Edwards, you're blocked, brother. You're gonna come in at the end of the lecture and try to make comments about something that you have no knowledge of. Okay, this is the problem with our people. Okay, you have no other intentions but bad intentions to come on to a platform that makes sense and bring nonsense to that platform. That's a fool. Okay? That is a complete fool. Let's continue. Indeed, I take it to be generally true that in all cases, once again, indeed, I take it to be generally true that in all cases where the subject is in the nature of a plaintiff, to recover anything from the king, his only remedy at common law is to sue by petition to the person of the king. You hear that? To the person of the king. Not to any king, but the person of the king. Because people change positions, don't. Meaning somebody can be sit in the position of the king, but be a de facto king. Okay? It's very, very important that you understand that. So when an issue in regard to the king's property is being questioned within the court of law, i.e. the king's court, it must be by a petition to the king or the king's council, i.e. the king's bench. By no other way can it be done, all right? We must comprehend this. This is what you're reading. For as I said before, when upon a title found for the king's by office, the subject comes into to reverse the king's title or to show his own right, he comes into the nature of a defendant and is admitted to interplead in the case with the king in defense of his title, which otherwise will be defeated by the finding of an office. This is why we have the corporation soul, because the corporation soul represents the seat of the monarch. And if nobody's sitting in the seat of the monarch, then there's no petition to the king, but the king ain't there. And the only person you could petition to is somebody acting as the king's counsel. Okay? All right? Petition about the property of the king when there is no king. So we must understand language by understand political science of English, and only for you to understand that, you must be an heir. Okay? 442. Let's go on. It appears that when a petition to the person of the king is properly presented, the usual way is for the king to endorse or underwrite soit juret set el parte, let right be done to the party, i.e., restore the king's peace. Okay? Upon which, unless the Attorney General confesses the suggestion, a commission is issued to inquire into the truth of it, after the return of which the king's attorney is at liberty to plead in bar, and the merit shall be determined upon issues of demurrer as in suits between subject and subject. Okay? You must comprehend the language. Point 447. In closing. All right? In closing. There is no other part of the common law besides that which I have considered, which can be any person, be part itself. There is no other part of the common law besides that which I have considered, which can by any person be pretended in any manner to apply to this case, but that which concerns corporation. The applicability of this, the Attorney General, with great candor, has expressly waived. Okay? No one is going to talk about that. I don't care if it's the prosecutor, the Attorney General, an attorney. If you're not of the King's Counsel, you are not going to talk about this argument that we are raising on behalf of this estate. Okay? No one can raise this argument like we're doing. But as it may be urged on other occasions, and as I wish to give the fullest satisfaction, I will say a few words to that doctrine. About what? Corporations. Suppose, therefore, it should be objected that the reasoning I have now used is not conclusive, because inasmuch as a state is made subject to the judicial power of Congress, its sovereignty must not stand in the way of the proper exercise of that power, and therefore in all cases, though in no other, a state can only be considered as subordinate corporation merely. Once again, a state can only be considered as a subordinate corporation merely because the corporation is not a constitution, not a document of sovereignty. It's a document of limitations. Okay, so it's limit your actions. You are not a sovereign. All right, you are not a sovereign. I answer first that this construction can only be allowed at the utmost upon the supposition that the judicial authority of the United States, as it respects to states, cannot be effectuated without proceedings against them in that light, a position I by no means admit. Second, that according to the principles I have supported in this argument, admitting that the states ought to be so considered for that purpose, an act of the legislature is necessary to give effect to such a construction, unless the old doctrine concerning corporations will naturally apply to this particular case, which it does in our instance. All right. Third, that as it is evident that the act of Congress has not made any special provisions in this case, grounded on any such construction, so it is to my mind perfectly clear that we have no authority upon any supposed analogy between the two cases to apply the common doctrine concerning corporation to the important case now before this court. Okay, check it out. I take it for granted that when any part of an ancient law is to be applied to a new case, the circumstances of the new case must agree in all essential points with the circumstances of the old cases, i.e., precedents, i.e., stare decisis, i.e., case law, i.e., common law, to which that ancient law was formerly appropriated. You better understand it, because your citizenship depends upon it, as United States versus 1 Kim R stated. Citizenship must be interpreted according to the English common law. Now, there are, in my opinion, the most essential differences between the old cases of corporation to which the law intimated had references, and the great extraordinary cases of the states simply possessing as to everything simply related to themselves, the fullest power of sovereignty, and yet in some other defined particulars subject to a superior power composed out of themselves for the common welfare of the whole. The only law concerning corporations to which I can see the least reference is to be had is the common law of England on the subject of corporations. Okay? No one want to address that. Why? Let's see why. I need not repeat the observation I made in respect to the operation of the law in this country concerning corporations. The word corporation, in its largest sense, has a more extensive meaning than people generally are aware of. Yes, that includes you, citizens. That includes you. Any body of politics, whether a corporation, soul, or a republic known as an aggregate, meaning made up of a body, whether its power is restricted or transcended, it is in this sense a corporation. You hear that? The king, accordingly, in England is called a corporation. So also, by a very respectful author in his abridgment, is the parliament itself. And in this extensive sense, not only each state singly, but even the United States may without impropriety be termed what, y'all? A corporation. Y'all better listen. I have therefore, in contradiction to this large and indefinite term, used the term subordinate corporation to United States corporation or state corporation because they are subordinate corporation because they were created by either parliament or the king. And very rarely is it of the latter. Okay? Very rarely is it of the latter. Okay? It says, I have therefore, in contradiction to the large and indefinite term used to term subordinate corporations, meaning to refer to such only as alone capable of slightest application for the purpose of the objection, whose creation and whose powers are limited by the law. So the law does not declare you're sovereign. The law says you have limited sovereignty. All right. The difference between such corporations and the several states in the union as relative to the general government are very obvious in the following particulars. So everyone who will watch this lesson, check out the particulars, okay? First, in closing, a corporation, I repeat, a corporation is a mere creature of the king or parliament, very rarely of the latter, most usually of the former only, okay? It owes its existence, its name, its laws, except laws as are necessary incident to all corporations merely as such, to the authority which created it. So statutes are a mere creation of the creator. So if you created by law and became a statute, you're only an interpretation of the law. You're not real if you drop your interpretation. Okay? A state does not owe its origin to its government of the United States. You hear that? In the highest or in any of its branches. It was in existence before it. It derives its authority from the same pure and sacred sources as itself, the voluntary and deliberate choice of who? The English people. All right? The English people. Second, a corporation can do not act. A corporation can do no act but what is subject to the revision either of a court of justice or of some other authority within the government. A state is altogether exempt from the jurisdictions of the court of the United States or from any other exterior authority unless it is special instances where the general government has power derived from the Constitution itself. Third, corporation is altogether dependent on that government to which it owes its existence. Its charters may be forfeited by abuse. Its authorities may be annihilated without abuse by an act of the legislative body, not the executive body, not a municipal body, not a corporate body, but a legislative body. A state, though subject in certain specified particulars to the authority of the government of the United States, is in every other respect totally independent upon it. The people of the states created, the people of the states can only change its constitution. Upon this power, there is no other limitation but that imposed by the Constitution of the United States, and that it must be a republic form of government, and that resides in what we call an interregnum. All right? We must comprehend that. All right? We must comprehend that. So in lieu of that, Title 18 of the United States Code clearly says, Whoever falsely and willfully represents himself to be a citizen of the United States shall be fined under this title or imprisoned no more than 3 years or both. So you need to ask yourself this question: are you a citizen? Legally. Title 18 of United States Code, Section 912. Whoever falsely assumes or pretends to be an officer or employee acting under the authority of the United States or any department, agency, or officer thereof, and acts as such or in such pretended character, demands or obtains any money, paper, document, or things of value shall be fined under this title or imprisoned not more than 3 years or both. Section 913. Read it. Whoever falsely represents himself to be an officer, agent, or employee of the United States, that includes ambassador, consular, etc. All right? Whoever assumes to be an agent or employee of the United States and in such assumed characters arrests or detain any person or in any manner searches the persons, buildings, or other property of any person should be fined under this title or imprisoned not more than what? 3 years or both. Section Title 18, Code 1015. And closer. Whoever knowingly makes any false statement under oath in any case, proceeding, or matter related to or under or by virtue of any law of the United States relating to naturalization, citizenship, or registry of aliens, or whoever knowingly with an intent to avoid any duty or liability imposed or required by law denies that he has been naturalized or admitted to be a citizen after having been so naturalized or admitted, whosoever use or attempts to use any certificate of arrival, declaration of intention, certificate of naturalization, certificate of citizenship, or other documentary evidence of naturalization or citizenship, or any duplicate or copy of naturalization or citizenship, or any duplicate copy thereof, knowing the same have been procured by fraud or false evidence or without requirement, appearance, or hearing of the applicant in court, or otherwise unlawfully obtained, or whomsoever knowingly makes any false certificate, acknowledgement, or statements concerning the appearance before him or taking of an oath or affirmation or the signature, attestation, or execution by any person with respect to any application, declaration, petition, affidavit, disposition, certificate of naturalization, certificate of citizenship, or other paper or writing required or authorized by the law relating to immigration, naturalization, or citizenship, or residency, or alien, etc., is in violation of the law. Okay? Violation of the law. So with that being said, let's see. The Crown. The Crown broadly represents the state in all aspects within the jurisprudence of the Commonwealth rim and their subdivisions such as crown dependencies, overseas territory, provinces, or state. The term can be used to refer to the office of the monarch or the monarchy as the institution to the rule of law, or to the functions of the executive, i.e. the Crown and Council, the legislative, the Crown and Parliament, and judicial, the Crown, known as the King's Bench. You hear that, y'all? I represent all of this. The concept of the crown as corporation so developed first in the Kingdom of England as the separation of the physical crown and property of the kingdom from the person and personal property of the monarch. What is the concept of the crown? Let's check it out. The concept of the crown took form on the feudal system, though not usually this way in all countries that had the system. In England, all rights and privileges were ultimately bestowed by the ruler. Land, for instance, was granted by the crown to a lord in exchange for feudal services, and they in turn granted land to lesser lords. One exception was that concerning free and common soakage. Okay, free and common soakage. This type of feudal tenure, the owners of the land held its soakage held its subject only to the crown. When such land became ownerless, they are said to escheat back to who? The crown. returned to directly ownership of the crown because it was part of what we call crown land, and crown land is intel. Now, if the crown is not there, then it becomes banda vacatinia. Banda vacatinia is land that's being entrusted to the overseer or that which is based upon the state. Okay? We go here, crown land. Crown land, also known as royal domain, is a territory area belonging to the monarch who personifies or incorporates or what we call incorporate, personify, or what we call incorporate, personify, or incarnate. All right, incarnate means the same thing. Incarnation of the crown is equivalent of an intel state and passed with the monarchy being acceptable from it. So an intel state is represented by the crown, which is the monarch, and it states that the crown land, which is the intel state, cannot be separated from the crown because the king personifies it. Okay, the kings personifies that, and let's close out on this in regards to these two cases that qualifies that in closing. State versus elevated company, as well as state versus Standard Oil Company. In closing. In modern usage, in modern usage, estate signifies the falling of property to the sovereign for one of an owner. And this category embraces not only property which has no other owner, but also property with owners or whose owner's whereabouts is unknown. Under the common law of England, estates came to be classified as another branch of the king's ordinary revenue. What was originally an incident of tenure is now an incident of sovereignty. The doctrine of estate at the early common law operated only upon that which was the subject of tenure, since it related to the reversionary right of the lord to take for one of a tenant, was eventually extended to include personal property, tangible and intangible. The principle was that the right to take that which belonged to no one appertaining to what? The crown as part of what? The crown's jurisprudence. That's the king's radical title. The crown steps in to take the property because it is what? Vacant. Property described as banda vacatina is taken or assumed by the state as its own. Property of this class falls into the crown as a matter of right and the exercise of its sovereign power. In personal estates which are allodial by law, the king is last heir when there is no kin. Did you hear that? When there is no kin. Now, let's go a little bit further in this case. But far more important than the procedural difficulties of rivals or even multiple systems of practice and procedures is the grave substantive danger of conceding to the state a preferred position in the courts of law as a plaintiff. One of the signal triumphs of the common law as distinguished from continual systems of jurisprudence is that for centuries it has been a recognized principle that everyone, include everyone, is subject to the rule of the law, and that no man is above or beyond the law, said Braxton, the greatest of the earliest writers on English common law. Rex non debet esse sub hamne set sub de el subleka quia lex facere regime, means that the king should not be under any man, but under God and under the law, because the law makes the king. Did you hear that? The law makes the king. We qualify it, and also in State versus Parson, it says the same thing. The same exact thing. All right? Same exact thing. So with that, I'll go back and close out on the 1911 Encyclopedia Britannica, dealing with the government or the political science of English people that America adopted, known as the common law of England, for the common people known as Anglo-Saxons, as established in the case law, in Ray Amahasan, as well as United States versus Juan Kim Do or King Do. All right. It says here, Dr. R.D. Latham, who writes all that now is Arabic in the Kingdom of Morocco, all that now is Arabic in French province of Algeria, all that is Arabic in Tunis, Tripoli of Fezan is Berber. The explanation lies in the profound distinction of character, y'all. The Arab is a herdsman and a nomad. The Berber is a agriculturist and a townsman. The Arab has built his social structure on the Quran, which inculcates absolutism, aristocracy, theocracy. The Berber, despite his nominal Mohammedan ways, is a democratic with his Jimna or Witamat and his Kanun or unwritten code called the Magna Carta of the individual liberties as opposed to the community's good. Okay? Witamat is that which was created by those who are called the Council of Witten. And I'll pull that up in closing. Witten. Witten was the King's Council and the Anglo-Saxon government of England from before the 7th century until the 11th century. It comprised of important noblemen, including aldermen, thanes, and bishops. Meeting of the Wittens were sometimes called Wittenmont. So if the meeting of the Wise Council, going back to Alfred the Great, was called Wittenmont, and we just read in the 1911 encyclopedia that the Wittenmont was composed of Berbers, and we have incorporated as Berbers, and the Berbers were those who immigrated to Northeast Africa to here, what we call New Jersey, based upon New Jersey representing the crown, then is no more than befitting to call us the kings of England, okay? The heirs of England, okay? No one else can wear that title because based upon citizenship as established in United States versus Wynkim Art, the citizenship status of anybody here in what we call North America must be interpreted based upon, A1 said, what y'all? English common law. English common law. The citizenship clause of the 14th Amendment dealing with us who are emancipated from slavery and now given our freedom. In order for you to be free, you must adopt the English common law. If you want to remain a slave, continue on with the laws that you're practicing. All right? And if you practice those laws establish your status here as a foreigner or a foreign national or just simply somebody who just stateless. Okay? Just stateless. So with that, I'll leave the floor open for questions. If there are any questions. Any questions, my noble men and women? Any questions? If there are no questions brought before your king, then all I ask is that you honor your king by honoring your ancestors' law. And that's the common law of England, because that determines your citizenship here presently. Okay? The floor is open. Any questions? You better ask them now. It ain't gonna get better. It ain't gonna get no better than this. Any questions? So I assume everyone knows. The gift of understanding are the treasure of Allah, and he puts everyone with measure seems good unto himself. Okay, so you have a choice, all right, on how your status is going to be reflected from this day forward. You have a choice, all right? As the Archbishop said, anything outside of what we're talking about is just a belief. Okay? It's just belief. So with that, I'm going to greet you as I admitted you, and as always, in the eyes of our ancestors, especially King Edgar the Peaceful, the King of Peace, that's in peace and love. All your donations can be forwarded to $ Clifford Jefferson L or the Third Temple English Church of England. As well as any question, you can forward to the Temple website, or you can leave on the chat or the actual comment box, and we'll be surely to respond to those questions expediently. All right. So with that, I hope this lesson was enlightenment. Lord Joe stated that he's confused when you keep saying citizenship. What are you confused about in regards to citizenship? What are you confused about citizenship? Because there's only two types of citizenship: national, foreign national, and then a stateless person. If you're a stateless person, then you don't have any citizenship. If you do have citizenship, which denotes the status, then there's only two of them: a foreign national or a national that's not foreign. So what are you confused about in regards to the topic or the statement citizenship? I'm waiting for your answer. It don't make a difference. American nationals, American citizens is nothing outside of English. So neither is applicable. Neither is applicable. You're not an American citizen, nor are you an American national. You are an English national, which makes you an English subject. Because it just said, under the 14th Amendment, it must be interpreted by English common law. I didn't say American common law. It said English common law. Does that make sense, Lord Joe? Yes, citizen relates to a corporation based upon corporate domicile or corporate residency. But your residency determines what residency that you take based upon you allowing to be allowed to become a resident, which can only be two: a citizen or a resident. Residents are simply those who live in the area based upon their ability to be able to be employed there. And once again, your employment is citizenship based upon the eyes of the state citizenship or United States citizenship, because it had nothing to do with nationals of a country. So, Lord Joe, you need to watch this lesson a couple more times. I'm pretty sure it will answer your question in its entirety. You understand, Lord Joe? You know any platforms out there that you know of that are not biased to truth? We welcome the invitation to bring this life-saving word to them, okay? Because you are obligated to spread the word. If you're a citizen, if you are a subject, your job is to protect other citizens who are subject. And the only way you can protect a citizen who is a subject is based upon learning their subjectivity. Laws of why they're subject, and that's based upon understanding citizenship. So yes, you are an employee of the Third Temple English Church of England because it determines your citizenship as nationals. Okay? But it just so happened that your citizenship here as nationals happened to be a citizenship that deals with natural people because the corporation so is a natural person. All right. A corporation so is a natural person. All right. So with that, I'll leave the rest up for you all to conversate amongst yourselves to bring clarity to yourselves. But that's following the standard that has been set forth today, and that's understanding English common law, which determines your citizenship here in North America without having proof, but just by way of what we call operation of law. And with that, I say